Okay, we are streaming. We should be good to go. One moment. Okay, thank you for bearing with me, everybody. We are now streaming. We should be good to go. We obviously have some basic matters that we need to go through really quick. And one of those is, can the teams confirm all of your witnesses and your co-counsel are present with us?
Yes, everyone's here for the defense.
Everyone's here for the plaintiff.
What about for the plaintiff?
Yes, Your Honor, everyone's here.
Okay, great. And then do we have jurors? Are the jurors here as well?
This is Robin Andrews. I'm one of the scoring jurors. I'm here. I'm ready to go.
Well, this
Fantastic.
is Wade, scoring jury as well.
Darius Wade, is that who just spoke?
Yes.
And do we have a Lindsay Reeser? It appears we maybe are missing one scoring juror. Let me just make sure I haven't forgotten to bring somebody in. Although I was the one who was late, so you would think that's not the case. It looks like we have Yep, okay. I'm going to send a text to make sure that we're no longer waiting for them. And in the meantime, we'll continue going through our basic stuff. All right, at this time, will the attorneys please enter their appearances?
Yes, Your Honor. Good morning. My name is James Betzelos, and I, along with my co-counsel,
Alice Fagan.
we represent the plaintiff, Mr. Cam Donaldson.
Good morning, Your Honor. My name is Amanda Wayne, and along with my co-counsel, Jessica Cox, we represent Ms. Karen Baja.
And do you have team names you can each share with us?
Yes, Your Honor. The plaintiff's team name is Quandary, and I'll change my name to that right now.
The defense
Oh, you're okay. I don't think you... Oh, go ahead. I'm sorry.
I was going to tell you our team name is Mount Wilson.
Not Wilson. For the scoring jurors who are currently here with us, do you know anyone on either team to a degree that will affect your ability to provide an unbiased evaluation?
This is Robin Andrews. No.
This is Darius Wade. No.
All right. Given that there are no conflicts, we can move on. All right, so is the plaintiff ready to proceed with this matter?
Yes, Your Honor. Before the plaintiff proceeds to opening statements, we do have some preliminary matters as well as one motion for the court's consideration.
Absolutely, and we will address those each in their turn. But before we do that, I just want to make sure everybody's ready. So is the defense ready to proceed in this matter?
Your Honor, yes, defense is ready to proceed. We also have a few housekeeping and substantive matters.
Okay, and then before we do, I'd like everybody, so that's the witnesses as well as the attorneys here, to raise their right hand. Please indicate by saying "I do" if you swear to abide by the rules of this proceeding and conduct yourself in a manner that is honorable to the forum.
I do.
I do.
And I obviously don't know for sure if everybody did, but I'm going to assume that everybody is agreeable to that very simple oath. All right, so we're now calling the case number 082263, Cam Donaldson versus Karen Beja. I understand both parties have some housekeeping matters, and I would expect we also have some motions in limine that we need to deal with. Let's start with the housekeeping matters. So does the plaintiff have any housekeeping matters?
Yes, Your Honor. For our first housekeeping matter, may we presume that all objections are heard outside the presence of the jury, or should we ask?
Absolutely. Go ahead. I'm sorry.
Or should we ask permission to approach for a constructive sidebar?
Because of the complexities of this forum, and obviously because I have difficulty with some of the technical stuff, we're going to assume that we have a constructive sidebar each time. So thank you for bringing that up.
Yes, Your Honor. And also, may we presume that all witnesses have been constructively sworn in?
Yes, we may.
Your Honor, at this time, the plaintiff moves to invoke Federal Rule of Evidence, Rule 615, excluding all witnesses aside from the defendant from the courtroom during this proceeding.
We will constructively sequester all witnesses except the parties themselves.
Yes, Your Honor. And with that, the plaintiff has no further housekeeping matters.
Does the defense have any housekeeping matters?
Your Honor, the only other housekeeping matters we have is, would you like us to request every time we republish already admitted exhibits, or maybe just go ahead and publish them?
Once it's admitted, you don't need to ask me for permission. But what I would ask is that you make a record of it. And that is actually here somewhat practical. It's for our benefit, the scoring jurors' benefit, and my benefit, so that if we have some sort of hitch where we should be seeing something that you intend to be sharing, but we don't see it, we'll be able to bring that to your attention.
Of course. Other than that,
Any other housekeeping matters?
We just have two substantive matters.
Okay. Given that we're done with the housekeeping matters, we'll proceed to the motions in limine. Does the plaintiff have any motions in limine?
Yes, Your Honor. We have one motion. We are seeking a pretrial ruling on the admissibility of a petition for a temporary restraining order, which has been bait stamped in the record as 0016. For Your Honor's edification, the petition was filed by the deceased, Lou Donaldson, against the defendant in today's matter, Karen Beja, about 2 months prior to his disappearance. The statements contained within the petition are all exceptions to the hearsay rule pursuant to Federal Rule 8033 and Federal Rule of Evidence 804B1. In addition, the statements contained within the petition fall within the residual exception to the hearsay rule pursuant to Federal Rule of Evidence 807. If I may be heard.
You may be heard, yes.
Thank you, Your Honor. With respect to the first point, the statements fall under the then existing state of mind exception to the hearsay rule pursuant to Federal Rule 303. The statements contained within the petition indicate Mr. Donaldson's then existing state of mind, which was that he had a plan and he had an intent to seek a divorce from the defendant, Karen Beja. In addition, the statements also reflect how he was feeling at the time, which was that he specifically did not feel safe around the defendant, Karen Beja. With respect to the second point, the statements are also exceptions to the hearsay rule under 804B1, as the declarant, Lou Donaldson, is currently unavailable. The statements were given at a prior court hearing, which were held in order to determine whether there was enough evidence to issue a temporary restraining order, and the witness, that being Lou Donaldson, was subject to cross-examination. Now, finally, the statements contained within the petition are admissible under the Federal Rule of Evidence 807. Now, under the residual exception to the hearsay rule, statements may be admitted if they are supported by sufficient guarantees of trustworthiness after considering the totality of the circumstances, and it is more probative on the point for which it is being admitted and offered than any other evidence that the proponent can obtain through reasonable efforts. Now, the very statements in this petition reflected genuine fear for Lou Donaldson's own life, further evidenced by the very filing of this petition. This was the only way that Lou Donaldson felt that he could ensure his safety from his wife. And we're talking about a man who worked with tigers and lions on a daily basis, wild animals that could attack at any moment. And despite all that, his greatest fear remained his wife. When looking at the totality of the circumstances, there is sufficient guarantee of trustworthiness that Lou Donaldson would not lie in open court as to the reasons why he wanted to get a restraining order and why he did not feel safe at the time. And for those, moreover, because Lou Donaldson is not here today to testify to these statements, they have high probative value in proving the defendant's motive in today's case. And for these reasons, we ask the court to rule in the favor of the admissibility of the evidence.
Okay, and I'm going to obviously allow the defense an opportunity to respond. Before I do, as an offer of proof, what would you be using this to prove to the court?
We would be offering this proof as the defendant's motive in that Lou Donaldson was seeking a divorce and that she felt that her lifestyle was threatened. Moreover, it's going to be probative of the fact that he did not feel safe around her during the 2 months prior to his disappearance.
Okay. Does the defense have a response to this motion?
Yes, Your Honor, and I'll handle those in stride as they came in. So first, under Rule 8033, a then existing mental or otherwise emotional condition, that rule is generally understood to be happening immediately after the event occurred. The order that we have here, this temporary restraining order, very obviously was something that Lou Donaldson took time to write out and did not happen immediately after an event. While it may have to do with what Lou Donaldson believed to be true, it is not evident of his then existing mental, emotional, or physical condition, as we have no timestamp on this. There's no evidence in the restraining order itself of when it was filed, filing after some kind of event that had happened. And so it doesn't fall under that exception. Additionally, Your Honor, if we look under Rule 807, which opposing counsel brought up, this temporary restraining order that we have doesn't meet a specific element of the cause of action that plaintiff has to prove. While they did cite that it could have proved motive, motive is not an element of a wrongful death claim. The element of the wrongful death claim here would be intentionally causing Lou Donaldson's death. But Your Honor, the fact that she threatened him is not actual evidence that she did in fact kill him. So it doesn't go to show an element here, and it doesn't meet the requirements of Rule 807. Additionally, we don't have any trustworthiness requirements because this is a filing made by Lou Donaldson, as opposing counsel pointed out. Because it's a filing made by Lou Donaldson, it is hearsay in the fact that these are statements by Lou Donaldson who's not here. While opposing counsel stated that under Rule 804B1, it could have come in as a statement made to a court, Your Honor, we don't have any evidence that this was made under oath. We have no evidence that there was cross-examination allowed. All we have is a filing that was submitted. There's no evidence that this filing was actually returned to us from the court, and because of that, it doesn't fit under this exception as well. Additionally, Your Honor, there has been no evidence submitted through an offer of proof that this temporary restraining order, that's simply a copy of a filing made, meets any kind of authentication requirements under Rule 901 or 902. So we ask this court at this time to deny this motion to exclude.
Okay, having heard the arguments of both parties, I'm going to withhold ruling on the motion right now. I'm going to have to see how the testimony develops around this potential exhibit to really understand what its purpose is going to be and candidly what it is. It's just the nature of the forum that I've not seen this document. So I'll withhold ruling at this time. Does the plaintiff have any further motions in limine?
No, Your Honor.
Does the defense have any motions in limine?
Yes, Your Honor, we just have two brief ones. Plaintiff may try to elicit testimony from Taylor Pride that Ms. Baja refused to take a polygraph exam. Just for Your Honor's understanding, Mr. Pride was an investigator that Cam Donaldson hired to look into the death of her father. He spoke with the Sheriff's Department and learned that Ms. Baja refused to take this exam. Under 702, this doesn't help the trier of fact to deal with credibility, and under 403, it is only prejudicial with no probative value.
Does the plaintiff have a response?
Yes, Your Honor, we do not intend to elicit such testimony today.
So are you willing to stipulate that it will not be admissible, given that you don't intend to use it?
Yes, Your Honor.
All right, well, given the stipulation, I will grant the motion.
Or the defense asked that any mention of Ms. Baja's prior misdemeanor be excluded from this case. For your knowledge, Ms. Baja was charged with misdemeanor assault when she was 17. Under Federal Rules of Evidence 609, it doesn't qualify as an impeachment offense and should be excluded from this trial.
Does the plaintiff have a response to this motion, Limine?
Again, Your Honor, we do not intend to elicit such evidence today.
Okay. Are you willing to agree that you would keep it out, or do you want to retain the right to potentially go up on this issue if for some reason the testimony were developed in that way?
In that case, Your Honor, yes, we do. We would like to confront that issue if need be during the trial.
Okay. As a basic matter, I'm going to grant the motion. But if at any time you feel like the door has been opened, you're welcome to bring that up with the court. Okay?
Yes, Your Honor.
Any other motions in limine?
From the defense, we are prepared to proceed.
All right. Is the plaintiff prepared for opening statements?
We are, Your Honor.
Okay. Give me 1 second. All right. You may proceed when you're ready.
$10 million. We are here today because the defendant, Karen Baja, killed her husband, Lou Donaldson, for $10 million. 2 days after Lou Donaldson filed for a temporary restraining order against his wife because he felt unsafe around her, a new will suddenly appeared. Lou Donaldson's will was changed, so now all of his estate was awarded to the defendant in the event of his death or his disappearance. Now, 2 weeks after the defendant was heard arguing with Mr. Donaldson after he told her he wanted a divorce, he suddenly disappeared. After that fight, he told his son, "If anything were to ever happen to me, I want you to be sure to have the police look into Karen, because she will be the one that's responsible for my death." 2 months. 2 months passed between the moment that the defendant thought she was going to lose it all to the day that Lou Donaldson disappeared. The defendant waited patiently because she had grown accustomed to the lifestyle that Lou Donaldson had given to her. And she wasn't going to let anyone, not even him, take that away from her. So she created a plan to forge Lou Donaldson's will and then kill him for $10 million. Members of the jury, my name is Alice Vagan, and I, along with my co-counsel James Bitselis, represent the plaintiff in today's case, Cam Donaldson. It is our burden here today to prove to you all, by preponderance of the evidence, that the defendant, Karen Baja, is responsible for the wrongful death of her husband, Cam's father, Lou Donaldson. Now, when Lou and the defendant first met, he was 20 years older than her. He was a successful businessman. And Karen and the defendant didn't come from much. She had a poor upbringing. Now, when she met Lou Donaldson, he was also married. He had a family, a wife, a son. But that didn't matter to the defendant because she saw her golden ticket in Lou Donaldson. So Lou divorced his wife and got together with the defendant. And together, they opened up Wild Wild Life Tiger Emporium, with Lou's money, of course. Now, Wild Wild Life was a sanctuary dedicated to endangered animals and the preservation of big cats. Because you see, for Lou, his passion was these beautiful and majestic creatures. And he wanted to create a safe place for these endangered species. Or as for the defendant, he just wanted a safe place for herself. Now, after the divorce, Cam went to work with his father at Wild Wild Life. For more than a decade, they worked side by side every single day, realizing his dad's dreams and passions. But on August 17th, 2012, Cam said goodbye to his father for the last time. Now, at that moment, he didn't know that this was going to be the last time that he would ever say goodbye to his father. He thought that he would see him back at work on Monday morning. He thought that he could stop by his house on Sunday and there would be Lou cooking up one of his famous Sunday dinners. Cam was going to tell you all today that he saw his father, a perfectly healthy man with no plans to leave, walk out of that office door on Friday night and never come back. And that's because the defendant's lifestyle had been threatened. So she made sure that this was Cam's final goodbye. Now you're also going to hear that that weekend that Lou disappeared, Cam saw the defendant back at Wild Wild Life. He saw her break in to steal a lockbox. A lockbox that had contained Lou's will, the real will, the original one that Lou had actually signed. The one that had equally divided his estate between Cam, Cam's mother, Wild Wild Life, and the defendant. Now, Cam is also going to tell you that this is the last time anyone would ever see this will, because the one that the defendant later presented in court gave her everything. The defendant didn't want a cut, no. No, she wanted it all. And you're also going to hear today how back at Wild Wild Life, they have a meat grinder. And that meat grinder can dispose of a human body. And you're all going to hear tonight that you need at least 2 people to operate that meat grinder. And you're going to hear how in the morning of August 18th, 2012, just a few hours after Lou Donaldson was last seen alive, the defendant was at Wild Wild Life with her brother. Her brother, the deputy sheriff at the Pioneers County Sheriff's Office. The same department that investigated the disappearance of Lou Donaldson. And the same department that would have arrested the defendant had she been charged with anything. Now, members of the jury, before we go any further, we need to confront a few basic realities here. Because the truth is, you're not going to hear about a body being found. You're not going to hear about DNA evidence being tested. You're not going to hear about blood being tested. No one here today is going to get up on that witness stand and tell you that they saw themselves, Karen Baja, kill her husband, Lou Donaldson. But that's okay. Because here's what you will learn here today. A perfectly healthy man with a family, with no plans to leave, disappeared without a trace after the defendant had threatened him multiple times. Members of the jury, Lou Donaldson was dead. In fact, you're all going to learn today that it was the defendant herself who petitioned the courts to have him declared legally dead 5 years after he was last seen alive. You're going to learn that she made this difficult decision because it was time to move on. It was time for closure. The truth is, she needed him to be legally dead. That way, she can officially collect on his life insurance policy. And the first take that the courts let her, she ran straight from the courthouse right to the life insurance company to get her payout. Members of the jury, it is our burden here today to prove to you by preponderance of the evidence that the defendant, Karen Baja, is responsible for the wrongful death of Lou Donaldson. And at the end of today's trial, once you've seen the evidence and heard all the testimony, it will be clear that we've met our burden. Because you're all going to hear how 2 days after Lou Donaldson filed for a restraining order against his wife, his will was forged to solely benefit her. That 2 weeks after they were last heard arguing, and he told her that he wanted a divorce, he suddenly disappeared. 2 months it took for the defendant to complete her plan to keep her lifestyle by any means necessary. Now, at the end of today's trial, my co-counsel, James Fitzellis, will come before you, and he will ask you to deliver a verdict. He will ask you to deliver a verdict with the evidence, the testimony, and that common sense and justice for both Cam and Lou demand. We will ask you to to find the defendant Karen Baja liable for the wrongful death of Lou Donaldson.
Thank you, counsel. Does the defense have an opening statement they wish to present?
Yes, Your Honor. May it please the court, counsel, members of the jury, we are here today because this is the plaintiff's $10 million opportunity to get her claws in her father's fortune. You see, there have already been 2 investigations that have looked into these same set of facts. The Summit Life Insurance Company determined that Karen Baja has done nothing wrong. And the Pioneer County Sheriff's Department has never put her in cuffs, sent her to jail, or even charged her. Folks, we are here today because this is the plaintiff's last shot. My name is Amanda Wayne, and along with my co-counsel Jessica Cox, we have the pleasure of representing Karen Baja. Now, let me tell you a little bit about Ms. Baja. Ms. Baja loves big cats. You heard earlier, she and her husband opened Wild Wildlife Sanctuary together. They have made it a place for these majestic creatures to spend the rest of their days in safety, right here in Pioneer, Statesville. Now, Mr. Donaldson and Ms. Baja got married on May 29th, 2001. And a few short years later, in 2005, Mr. Donaldson filed for a life insurance policy. He named Ms. Baja as the beneficiary of that policy. So after Mr. Donaldson disappeared, Ms. Baja did declare him legally dead. She filed for that policy to help keep their dream alive, Wild Wildlife. Now, before she could get any money, the company had to come in and conduct an investigation. And you're going to get to hear from their investigator, Mr. Chris Renard. And he's going to tell you he was looking into 2 different things. Did Ms. Baja have anything to do with Mr. Donaldson's disappearance? Is this alleged forged will, is there any truth to that? Now, he's going to walk you through, as a handwriting expert, how he studied this will, how he studied the signature. He's going to walk you through his comparisons, and after reviewing the totality of the circumstances, he's going to tell you that will, it's genuine. He's also going to walk you through his investigation about Mr. Donaldson's disappearance and how he couldn't find any wrongdoing on Ms. Baja's part. And if there is one party in this case that has no skin in the game, it's the insurance company. And they couldn't find any reason to not pay the policy. Now, I also expect you're going to learn a little bit about the Pioneer County Sheriff's Department investigation. It's an active case, so you're going to have very limited facts coming out of it, but what you are going to learn is that Ms. Baja, like I said earlier, she's never been charged. And the reason being, the night that Lou Donaldson went missing, August 17th, 2012, Ms. Baja, she wasn't even home. You see, sometimes big cats, they reject their cubs, and that had happened. A tiger mama rejected her babies. So it was up to Ms. Baja to make sure that those kittens were fed and warm. And when she opened the fridge that night, after staying for days caring for these cubs, lo and behold, she'd run out of milk. She'd run out of formula. So she did what any good mother would do. She grabbed her car keys and she headed out the door. She went straight to the store. She was able to get what she needed, but you know, when they say things happen, they happen in threes. Not only did she run out of milk, but her car broke down. And she had left her cell phone at home in her rush. So Ms. Baja was able to get a phone, and she called the one person who she's relied on her whole life. She called her big brother, Sheriff Deputy Carl Bannister. Now, Deputy Bannister, he was working the overnight shift, and you're going to hear a little bit from him today, too. And he's going to talk to you about how he came to check out our car to see if he could fix it. Unfortunately, he couldn't. So he took Miss Baja with her groceries in tow back home. Miss Baja, she didn't call her husband. She didn't call Lou Donaldson. She's going to talk to you today, and she's going to be upfront. She's going to tell you that she and Mr. Donaldson were having some issues. They've been married for 11 years. They were starting to have some troubles. Now, he did file this temporary restraining order, and it was denied by the court. And she's going to tell you he was a secretive man. He was a secretive man, but he was also a little eccentric. He had a pilot's license. And he loved to take off in his planes at a moment's notice. Often, he wouldn't file a flight plan. And I expect you're going to learn that he would fly even when his license was suspended. And that Miss Baja, she does not know how many planes that man had. So that night, she didn't call Mr. Donaldson. She didn't call him because she didn't know if he'd be home. But she did know that her big brother would be. There are a few things you're never going to learn. You are never going to learn, where is Lou Donaldson? We can't tell you. But more importantly, they can't tell you. And as the plaintiffs, they have the burden of proof in this case. It is their job to convince you that probably more true than not, Miss Baja did this horrible thing she's accused of. However, you're not going to hear any evidence, none, that directly links Miss Baja to Mr. Donaldson's disappearance. You're going to hear no evidence about where he's at or where his body is or how this horrible thing allegedly happened. And members of the jury, at the end of this case, you're going to be handed a jury instruction form. And on that form, it's going to tell you you can't base your decision off the possibilities. And all that you can be told for sure today is that both the Summit Life Insurance Company, who conducted a thorough investigation, and you're going to get to hear how thorough it was, found that Miss Baja did no wrongdoing. And the only other thing you're going to know for sure is that the Pioneer County Sheriff's Department hasn't arrested her. Members of the jury, third time is not going to be the charm today. We are here today because Cam Donaldson has a $10 million reason to take this last shot, take advantage for last opportunity. We look forward to presenting our case to you.
Thank you, counsel. Is the plaintiff prepared to proceed to its first witness?
Yes, Your Honor. The plaintiff calls Cam Donaldson.
You may proceed when you are ready, as the witness has already been constructively sworn.
Thank you, Your Honor. Good morning, Mr. Donaldson. Can you please introduce yourself to our members of the jury and spell your last name for the record?
My name is Cam Donaldson, Donaldson.
And do you prefer to go by Cam or Mr. Donaldson today?
Cam is okay.
Okay, Cam. Can you tell us, where do you live?
I live right here in Pioneer.
How long have you lived here for?
I grew up here, so my whole life.
And how are you related to Lou Donaldson in today's case?
Lou Donaldson was my father.
Were you close with your father?
I was extremely close with my dad. He was my best friend and my biggest mentor to me in work and in life.
How often would you see him?
I saw my dad nearly every day at work. Oftentimes I would stop by his house too for one of our traditional Sunday dinners.
Now, you mentioned you two work together. Can you tell us where?
Yes, I worked at my dad's Tiger Emporium business. It was called Wild Wildlife Tiger Emporium.
Tell us more about Wild Wildlife.
Sure. So Wild Wildlife is a big cat and tiger rescue emporium. My dad was really passionate about the rehabilitation and protection of big cats, and Wild Wildlife, I think, was the way for him to realize that passion.
And what was your specific role at Wild Wildlife?
So I was my dad's personal assistant for going on 20 years, and for the past 10, I was my dad's personal assistant and right-hand man at Wildlife. I did it all. I ordered the supplies, I wrote the checks, and I kept my dad's schedule. My dad used to joke a lot that I knew the business more than he did.
Sounds like a family business. Did mom also work there?
No, she had not. They were divorced by the time my father started the business.
Was your dad seeing anyone else after they got divorced?
Yes, he was seeing the defendant, Karen Bajia. She's the reason they got divorced in the first place.
See the defendant here in court today?
Yes, she is.
Can you please point to her and identify her by an article of clothing?
Yes, she is sitting at defense counsel table in the inactive Zoom box currently.
Let the record reflect that the witness has in fact identified Ms. Baja.
Now, Kim, when they first started dating, what did you think of their relationship?
Well, to start, I mean, Karen was 20 years younger than my dad, which I always thought was weird. She didn't come from the most fortunate upbringing, so
Objection.
I always thought that she was after his money.
Objection, Your Honor. At this point, we are going to object to the relevance of this testimony, as well as the speculation.
Counsel, what do you have to say to the relevance objections?
Your Honor, the testimony here was relevant because it has a tendency to prove that the defendant had a financial motive in taking intentional steps to kill her husband. If I may respond to the speculation objection.
Yeah, and actually, before you do, could objecting counsel expound on their speculation objection?
Yes, Your Honor. Opposing counsel has not laid any predicate that Mr. Donaldson would have knowledge of Ms. Bosch's upbringing or of her financial status outside of her marriage with Lou Donaldson, and because of that, that's the grounds for a speculation objection.
All right. So yeah, I'll hear the response now to the speculation objection.
Well, as to the speculation, Your Honor, we're not specifically asking the witness to inquire into the mind of why the defendant was interested in Mr. Donaldson. We're asking him of his personal opinion of why he thought why the defendant was with Mr. Donaldson. Moreover, the witness just testified that he knew the defendant for the past 10 years since they got married after the divorce.
I'm going to overrule the objection at this time. You're welcome to raise it again if you think that we get into an area where there is, in fact, speculation occurring, but I think he can testify as regards to his own beliefs.
Ma'am, can you please tell us, what did you think of their relationship?
Well, as I said, I never thought that, well, the fact that she was 20 years younger than my father, I always thought that was weird because she did come from a poor upbringing. So I thought that she was always after his money.
Now, Cam, we're here today to discuss what happened to your father, so I'm going to start asking you a few questions about that. So tell us, when was the last time that you ever saw your dad?
Last time I saw my father was August 17th of 2012.
Tell us more about your last moment with him.
Sure. So business as usual at work. My dad was working hard as always. And at around 6 p.m., he said that he would see me on Monday unless I wanted to stop by the house for one of our Sunday dinners.
Did you end up seeing him on Monday?
I did not.
Was that unusual?
Yes. As I said, I wrote my dad's schedule and kept up with him a lot. So the fact that he didn't show up to work was very unusual because he didn't have anything planned and any trips or anything like that.
Well, did your dad go on a lot of trips?
Yes. So my father was a pilot and would oftentimes take business related trips to Costa Rica in particular and he would fly out of a lot of airstrips and air hangars. He owned a few planes.
Well, would your dad ever go on any of these strips without telling anybody?
Well, sometimes my dad would fly kind of at a moment's notice. But again, he would never leave without telling his family or particularly telling me because I was his personal assistant. Another thing is my dad would never fly without his glasses. He was blind as a bat without them, especially in the cockpit.
Now, I want to redirect your attention to that weekend that you last saw your dad. Now, did anything unusual happen?
Yes. So that Sunday of that weekend, the alarm went off at the office.
And so what did you do?
Well, I live close by, so I figured I would drive by and see if there was any trouble or we might have had a break-in.
I'm now directing opposing counsel to what has been bait stamped as 004 and 005. I'm also directing the witness's attention to what has been bait stamped as 004 and 005. Your Honor, for your record, if you have the electronic PDF, it's on pages 28 and 29. Mr. Cam, do you recognize these photos?
Yes, I do.
Do you recognize the photo that has been bait stamped as 004?
Yes, that is the picture of the padlock that was on the front gate to our office.
And how do you recognize the photo that has been bait stamped as 005?
That is an entrance to that is the back entrance to our office.
And are these photos a true and accurate depiction of the padlock and the back entrance as you last saw them?
Yes, they are.
May the record reflect that I am now remarking what has been previously bait stamped as 004 as Plaintiff's Exhibit 1 and remarking what has been bait stamped as 005 as Plaintiff's Exhibit 2, striking all other identifying marks. At this time, the plaintiff moves to admit Plaintiff's Exhibit 1 and 2 into evidence.
Is there any objection?
No objection, Your Honor.
Right, they should be admitted.
Thank you, Your Honor. Permission to publish Exhibit 1 and 2 to the jury by way of screen sharing?
You may.
Now, Cam, tell us, what are we looking at here?
So the first picture is a picture of the padlock that has been cut. And as when I left work on Friday, of course, it was not cut, but it was cut when I got to the office on Sunday morning.
Okay, now going to the next picture, can you tell us what are we looking at here?
So that is the entrance to the back of our office. When I left work on Friday, last time I saw my dad, the entrance didn't look anything like this. It wasn't busted into. And when I arrived on Sunday, the entrance was busted into as it is in this picture.
Okay, now when you arrived to the scene of the break-in, did you see anybody there?
Yes, I did.
Who did you see?
Well, I saw the defendant, Karen, and some guy.
Did your dad mention to you that Karen was going to be at the business over the weekend?
No, he did not.
Now, did Karen herself mention to you that she was going to be at the business over the weekend?
No, she did not.
So when you arrived, what was Karen doing?
Well, she was carrying a lockbox.
And the man that you just told us you saw her with, what was he doing?
He was carrying a lock cutter.
Okay. I want to direct your attention back to that lockbox. Have you seen this lockbox before?
I've seen that lockbox hundreds of times.
And where have you seen it?
That is the lockbox that my father kept in his office.
Now, had you seen what was contained in that lockbox prior to that day?
Yes, I have.
And what was that?
My father's last will and testament. And I'm talking about the real last will and testament, not that one that Karen brought to the court.
We'll get to that in just a moment. But Cam, tell us, how do you know that your dad kept the will in that lockbox?
I was my father's personal assistant for over 20 years. And in the course of my business with my father, I took and looked over many important financial statements, business documents, and a will is certainly, of course, an important financial and business document.
All right, now I want to talk to you about that will. Do you know how your dad planned to divide his estate?
Yes, I do.
Can you tell us?
Sure. So in the real will, my father planned to split his estate into 4 parts. The first and second quarter were supposed to go to me and my mother. The third quarter was going to go back into the business, Wild Wildlife. And then the last quarter was supposed to go to the defendant.
So you've told us now that you're very close with your father. Did he ever tell you about a second will?
Absolutely not.
Did he ever discuss changing his original will?
Absolutely not.
So was that will the one that you just told us, the one that was later presented in probate court?
That was the will, yes.
No, was the will that you just described to us the one that was presented in court later?
Excuse me, absolutely not.
Now, where did that will come from?
That will came from Karen.
I'm directing opposing counsel to what has been bait stamped as 0014, and I'm directing the witnesses to what has been bait stamped as 0014. Your Honor, this is contained on page 53 of the electronic record. Cam, do you recognize this document that has been bait stamped as 0014?
Yes, I do.
And how do you recognize it?
That is the will that Karen presented to the court.
And is this document a fair and accurate copy of the will that she presented as you last saw it?
Yes, it is.
May the record reflect that I am now remarking what has been bait stamped as 0014 as Plaintiff's Exhibit 3, striking all other identifying marks. At this time, the plaintiff moves to admit Plaintiff's Exhibit 3 into evidence.
Is there any objection?
We have no objection at this time, Your Honor.
All right, it shall be admitted.
Permission to publish Exhibit 3 to the jury by way of screen share.
You may.
Thank you, Your Honor. Now, Cam, tell us, how is this will, the one that the defendant presented, different from the original will?
Well, as you can see, this will awards Karen my father's entire estate and the business.
And what was the total value of that?
That was about, with the insurance policy, about $10 million.
Okay. I'm going to ask my co-counsel to zoom into the second paragraph of this exhibit. Now, Cam, I'm directing your attention to the second paragraph. Can you please read to the jury the line that begins with "I appoint"?
Yes. I appoint Karen Baja to be the sole executor of this will. And if I should die or disappear, I give to Karen Baja absolutely all my real and personal property whatsoever.
Now, Cam, as you're reading this, is there anything about this language that's struck you as
And Your Honor, at this point, we are going to object as Mr. Donaldson is a lay witness and is about to go into an opinion as to the validity or his general opinion as to the meaning of this will. There are experts that are going to be present at court today that would be able to provide this opinion, but Mr. Donaldson is not one of them.
Do you have a response?
Yes, Your Honor, we're not asking Mr. Donaldson to give his expert opinion. We're not asking him to question the validity of the will. We will not be eliciting such testimony. We're simply asking him his opinion as a layperson, his thoughts on the language contained within within the alleged will.
What specifically, as an offer of proof, what specifically are you going to ask him about his thoughts? What do you anticipate his testimony is going to be?
We may proffer outside of the presence of the jury.
Yes.
We anticipate that he will say that he found this language. Excuse me. Well, we anticipate that he will say that this language was odd and that people don't typically plan on dying, or people don't typically plan on disappearing, but people do plan on dying. It's simply going to be his opinion as a layperson, not as an expert.
I'm slightly uncomfortable with it, but I will allow it. And obviously you'll be able to cross-examine on it. A good objection, but I will allow it at this time.
May I proceed, Your Honor?
You may.
Now, Cam, tell us in your own words, what about this language struck you as odd?
Sure. So that last paragraph that I just read, the language particularly die or disappear. I mean, I've never seen that language in a will before. People certainly plan on dying. I mean, that's why wills are written, but nobody plans on disappearing.
Now, Cam, when did the defendant provide this will?
Was 1 month after she petitioned to have my father declared legally dead.
What date was that?
That was August 17th, 2017.
And by that day, how much time had passed since he was last seen?
5 years on the dot.
Now, you've told us multiple times now that you're close with your father. To your knowledge, do you know if he had any enemies?
Not to my knowledge.
Do you know if he was seeing anyone else other than the defendant?
Not to my knowledge.
Do you know if he had any plans to fly away to Costa Rica on Friday, August 17th, 2012?
Not to my knowledge.
Do you know if he had any other vacations planned around that time?
Object.
Absolutely.
At this point, we are going to object to leading as opposing counsel, deferring the answers in her questions.
Good objection. I'm going to overrule it. I will ask counsel to start trying to ask more open-ended questions.
I'll move on to my next question. So tell us, Cam, what do you think happened to your dad?
Bottom line, Karen Baja killed my father.
And why do you think she killed him?
Well, I mean, she's threatened to kill him in the past. My father even applied for a temporary restraining order against her.
Are you personally aware of the outcome of this petition?
Yes, I am.
And how did that end?
Well, the petition did get denied, and that really worried me.
I'm directing opposing counsel to what has been bait stamped as 16, and I'm also directing the witnesses' attention to what has been bait stamped as 16. Your Honor, this is found on page 55 of the record. The petition for the temporary restraining order has been stipulated pursuant to stipulation 13 as being authentic, and at this time we are seeking to offer it into evidence once more.
Is there any objection? I know we likely have one.
Yes, Your Honor. As far as the temporary restraining order being stipulated as authentic, with respect, Your Honor, we did never stipulate to the authenticity of the restraining order, as this is a filing submitted by Lou Donaldson and was concluded in pretrial that it's not something that was received from the court. And we also do have objections under hearsay.
Do you have a response?
Yes, Your Honor. Pursuant to the stipulations located on page 10 of the electronic record number 13, all of the documents may not be contested on the basis of their authenticity. However, if opposing counsel is still unsatisfied with the authenticity of this document, then we ask this court to take judicial notice that this document is self-authenticating. As you can see clearly that there's a case number. It shows which district this was filed in. It shows that there's a stamp that says that it was denied. So there is proof that this is a genuine and accurate, authentic copy of the petition for the temporary restraining order as filed by Lou Donaldson on the date of June 12, 2012.
I just want to make sure I understand. This is in fact not a court order, though. Is that correct? It's an application that was made to the court. A petition.
Yes. This is the request, so the petition, and as evidenced by the stamp on the right-hand corner, it was denied by the court, the application, yes.
And specifically, as an offer of proof, what are you offering this document for?
We're offering this as a motive. Your Honor, we are offering this as probative of the defendant's motive in today's case. Specifically, if I may proffer outside the presence of the jury.
You may.
The second statement contained within the petition for the restraining order specifically indicates that Lou Donaldson was seeking a divorce from Karen Baja 2 months prior to his disappearance. Now, 2 weeks prior to his disappearance, he again threatened the defendant with divorce. Now, this is an ongoing, with the ongoing threat of divorce, we believe that it adds to the defendant's motive as to why she took intentional steps to wrongfully cause the death of Lou Donaldson.
I don't want to drag this out too much longer, but does the opposing counsel have any response to that?
Yes, Your Honor, but first we would just like to clarify something. Stipulation 13 specifically states that all transcripts in this record cannot be disputed as to authentic, and then states thus none of these documents to the transcripts. We would have an issue with stipulation 13 being interpreted to apply to all documents in this record, and that may be something that we have to handle post-trial, Your Honor. However, as to the authentication, to be a self-authenticating document from a court, which first we've established that didn't actually come from the court, it not only has to have a stamp from the court, it has to have a seal, it has to have a certificate, or it has to have a signature from the person at the court that supplied the record. There is no self-authentication rule here that would allow this document to come in. And additionally, we re-urge our objection that this document is hearsay, as these are statements by Lou Donaldson with no exception.
Okay, I'm going to sustain the objection and I will exclude that document.
Now, So you mentioned that after the temporary restraining order was denied. Is that correct, Cam?
Yes.
Now, how close was that petition denied in the time that your dad disappeared?
That was 2 months before my father disappeared.
Now, after that petition was denied, did you observe any additional arguments or marital issues between your father and the defendant?
Yes. In particular, 2 weeks before my father disappeared, he and Karen had a huge fight at the office.
Okay. I want to direct your attention to 2 weeks before your dad disappeared in that argument. What happened?
Well, I was at work and I was walking towards my dad's office and I heard tons of shouting. And as I got closer to the office, I saw Karen storm out. So I went to check on my father to see if he was okay. And when he walked out, I had never seen him like that before. He was just trembling and he just looked so nervous. I asked my dad, what happened? Are you okay? And my father said something to me that I will never forget. He
Your
said,
Honor, I'm sorry. I'm not sure if my mic was coming through there clear.
No, this is the first I've heard you, please.
Sorry, Your Honor. I didn't quite catch that.
Oh, I said this is the first I've heard you, but please go ahead with what I anticipate is an objection.
Yes, Your Honor. We are going to object at this time to any statements by Lou Donaldson made during this argument, as we believe that Mr. Donaldson is about to go into those statements specifically.
Do you have a response?
Yes, Your Honor. The statements that are going to be elicited fall under the then existing state of mind exception to the hearsay rule. Under 8033, Mr. Donaldson's statement indicates his then existing state of mind, which was that Lou Donaldson had a plan for his son to have the police investigate the defendant in the event that something had happened to him.
I'm going to overrule the objection and I'll allow testimony on that basis. I'll include a limiting order to the jury as well, that they are ultimately the ones who need to decide who caused the decedent's death. But I will overrule the objection.
Kim, tell us, what did your dad tell you after this fight?
my father told me something I'll never forget. He said, son, if anything ever happens to me, make sure you have the police look into Karen because she will be responsible for my death.
Now, earlier you mentioned that your father and you were very close. And I understand this is going to be difficult to talk about, but can you tell us how has his death affected you?
I mean, it's affected me in every way. No longer have my best friend. I no longer have my mentor. I no longer have my father. He is the first thing I think about when I wake up, and he's the last thing I think about when I go to bed.
I'm directing opposing counsel to what has been bait stamped as 003, and I'm now directing the witness's attention to what has been bait stamped as 003. Cam, do you recognize this photo that I'm showing you, bait stamped as 003?
Yes, I do.
And who is this a picture of?
Well, it's a picture of me and my dad.
And does this photo depict your father as he appeared in real life?
Yes, it does.
May the record reflect that I'm remarking what has been bait stamped as 003 as Plaintiff's Exhibit 5, striking all other identifying marks, and at this time plaintiff moves to admit Plaintiff's Exhibit 5 into evidence.
Is there any objection?
We have no objection, Your Honor.
Shall be admitted.
Permission to publish Exhibit 5 to the jury by way of screen sharing.
You may.
Now, Cam, tell us, what do you miss the most about your dad?
So I think it really the hardest thing about this was the shock of it at first. Going from seeing somebody every single day to having them being gone in an instant moment, a moment's notice really has been the most difficult for me. My father was the hardest working and best man I ever knew. He never let any adversity come in the way of achieving his goals. He was a self-made and good man at that. As I said, I really think it's, one of the hardest things to lose a parent, especially in the way that I did.
One moment, Your Honor, to confer with my co-counsel.
Absolutely.
Nothing further, Your Honor.
Does the defense have a cross-examination they'd like to conduct?
Yes, Your Honor, but first, may I constructively approach?
You may.
Your Honor, I just wanted to request your ruling on the interpretation of stipulation 13, as this would go to affect any other documents that are admitted during the trial. You've heard our arguments on it, so I just wanted to ask you if we could have your ruling on how to use that stipulation during this trial.
Sure. Would you please read the stipulation to me one more time?
Yes, Your Honor. So just for your reference, it's the second page of the stipulations in the packet. It's stipulation 13. It states all transcripts provided in these case materials are accurate and authentic and cannot be disputed on such grounds. Thus, none of these documents may be contested on the basis or alteration or inaccurate transcription.
Yeah, I'm going to view that as more narrowly and probably outside of this, probably intended to ensure that the transcripts of any witnesses can't be contested as inauthentic. Obviously, I don't anticipate we're probably going to run into this again, but if we do, we can talk about it.
Yes, Your Honor. And may we also take a brief 2-minute recess to construct a demonstrative that we intend to use during Mr. Donaldson's cross-examination?
Certainly. We will take a 2-minute recess. I have it at 10:10, so if we can have everybody back at 10:12, that would be appreciated. Do we have everyone back right now?
Yes, Your Honor. Before we proceed, may I quickly address the issue of the authentic exhibits? Pursuant to Rule 42A of the tournament, it specifically says, and I'm reading, all exhibits are authentic and original documents under the meaning of Article 9 and 10 of the Federal Rules of Evidence. So while the stipulation 13 specifically refers to the transcripts, Rule 42A of the tournament does indicate that all exhibits are authentic and original copies.
Would you like my response?
Sure. No, I think it's okay. I think that we're talking about two separate things. And until we have an argument, another one at least, another argument that's ripe for an examination of it, I think we should just proceed and do so in good faith. But if I understand, we have a stipulation. The stipulation says the transcripts are all true and accurate. Candidly, I perceive that this is a likely that way, so that if somebody tries to impeach someone with prior testimony or something like that, there can't be an objection that the transcript being used to impeach them is not accurate. And then I will take note that the rule says all exhibits are true and authentic, and I appreciate you bringing that to my attention as well. Is there any other concern at this time?
No, Your Honor.
No, Your Honor.
You may proceed when you're ready.
Mr. Donaldson, I just want to clarify something up that you discussed on direct examination. Miss Basha was always a co-owner of Wild Wildlife, right?
Well, I mean, she worked there with my dad, and then after he passed, she became the owner.
Mr. Donaldson, is it your testimony today that Miss Basha was not the co-owner of Wild Wildlife?
Karen was she was an owner in part with my dad. And after he was declared legally dead, she became the sole owner.
So, Mr. Donaldson, I just want to clarify your answer here. You agree with me that Miss Basha has always been a co-owner of Wild Wildlife, right?
Yeah, yes,
And so you discussed on direct examination this time that you showed up on a Sunday that you saw Miss Basha at the sanctuary. You didn't go there on that Saturday, did you?
I did not.
You didn't check out the gate on the Saturday before.
I did not.
You didn't look at the lock the day before.
Correct.
You didn't see Miss Basha cut the gate, right?
I did not.
You didn't see Miss Basha cut the lock.
Correct.
All right, so I next want to talk to you about your dad's habit of travel. Your dad had a lot of planes, didn't he?
Correct.
You don't know how many planes he had.
Correct.
You don't know where he kept all of them.
Correct.
But you do know that in August of 2017, your dad's pilot's license was suspended.
In August of 2017?
Excuse me, Mr. Donaldson, I misspoke. In August of 2012, your dad's pilot's license was suspended.
Correct.
And because of that suspended license, your dad didn't keep flight plans, did he?
Correct.
Now, Mr. Donaldson, I know you testified on direct examination that your dad would always tell you when he was going on a trip, right?
Correct.
What that really means is that you only know about the trips that he told you about, right?
My father and I had very open and honest communication. So my dad told me all the trips that he went on.
Well, Mr. Donaldson, common sense would tell us that if he didn't file a flight plan and he didn't tell you about it, you wouldn't know, would you?
Objection.
Do you have a response to what I think was a speculation objection? You
Compound,
cut out a little bit.
compound question, Your Honor.
I'm sorry, say that again?
Compound question, Your Honor.
Got it, okay. Do you have, I'm gonna sustain the objection. If you can split it up, if you're asking about two separate things, please split it up so you're asking about one at a time.
So, Mr. Donaldson, if your dad didn't file a flight log, there wouldn't be a log of where he went, right?
Correct.
And if your dad didn't tell you he was going somewhere and there was no flight log, you wouldn't know where he went, would you?
Correct.
All right, so the next thing I want to talk to you about is what you're getting out of being here today. You'd agree with me that if you died, you'd want the distribution of your estate to happen exactly how you intended, right?
Yes.
Your Honor, may I construct the Zoom screen for a demonstrative?
You may.
Now, while we're getting that up, Mr. Donaldson, you discussed on direct examination this original will that your dad kept in a lockbox.
Yes.
And it's your testimony that there was just that one copy.
Correct.
There weren't any other copies of that will out there.
Not to my knowledge.
And you don't have any evidence of who witnessed this will.
Correct.
And other than you, you haven't brought any witnesses with you today that can testify that this will even existed.
Correct.
But you knew what was in the will, right? The contents of it?
Yes, I do.
And according to you, this will divided things up into 4 ways.
Yes.
And a fourth of that, 25% of your dad's estate, would have gone to you.
Correct.
So you'd agree with me that at the time your dad's disappearance, that was around 1.25 million.
Yes.
But Mr. Donaldson, you're here today asking for $5 million, aren't you?
Yes,
And this original lockbox will, it didn't say that you were to be the beneficiary of your dad's life insurance, did it?
it did not.
But you're here today asking for your dad's entire $5 million life insurance policy, right?
Well, I'm asking for the insurance policy because my father, Karen, just caused my father's wrongful death.
Then I want to bring you back to my question. You're here today asking for the policy, aren't you?
Yes,
And I kind of want to go into that for just a moment. So at the time of your dad's disappearance, he was married to Miss Basha for 11 years, right?
correct.
And Miss Basha, as we know from when the estate was distributed, was designated as the beneficiary on that life insurance policy.
Yes,
And we can agree that she was made the beneficiary at least before your dad disappeared in August of 2012.
correct.
So we know that your dad didn't change the beneficiary in July 2012.
Not to my knowledge.
And we know that he didn't permanently change it in June of 2012.
Not to my knowledge.
He didn't change it, even though it's your position that Lou Donaldson was going to file for divorce during that period.
Not to my knowledge.
Mr. Donaldson, let me clarify my question for you. Mr. Donaldson, you'd agree with me that it is your testimony that during that time period, your dad was going to file for a divorce.
Yes, yes, he was.
But you don't have any record or actual filing of a divorce that was submitted, do you?
Well, he never really got a chance to file for a divorce.
Mr. Donaldson, let me wrap back around to my question. You don't have any actual filing or evidence that your dad did file for a divorce during that time period, right?
I do not.
All right, I want to go back to this original lockbox will. You're also asking, along with the $5 million life insurance policy, for the deed to Wild Wildlife.
Correct.
And that original will, it didn't give you the deed to Wild Wildlife, did it?
In my father's real last will and testament, correct.
And that lockbox will, it didn't give you the ownership.
Correct.
I want to talk to you about your involvement at Wild Wildlife. You worked there for, I believe it was 20 years.
20 years as my father's assistant, the past 10 at Wild Wildlife.
All right, so you worked there for around 10 years at Wild Wildlife. During that entire time, your dad didn't give you ownership of the sanctuary, did he?
Well, my father never intended on, he did not.
Your Honor, before we proceed, I move to strike this demonstrative evidence pursuant to Federal Rule of Evidence 403, as demonstrative is not a fair and accurate depiction of this testimony today and will have a tendency to actually confuse the jury. Cam Donaldson is not asking for anything himself. The jury has to make the determination of how much he's going to have today.
I actually completely agree. I think that under 403, this does have a tendency to confuse the issues before the jury. I think that's a very good objection. Obviously, we've had it here published to the jury, and it's been being created for a while. So I'm going to allow them to continue with the demonstrative. I will advise the jury that they are the ones who will determine damages. And that obviously, due to the nature of this proceeding, they need to listen to the court as well. Good objection, just due to the nature of where we are and the forum that we're in. I'm going to overrule for that purpose with that instruction to the jury, and I'll allow them to continue.
Your Honor.
So, Mr. Donaldson, I just want to recap what we've gone over. You're not here today suing to restore what your dad allegedly left you in that original lockbox will.
What I'm here today for is for justice for my father.
Mr. Donaldson, let me wrap you back around. You are not here today suing to restore what your dad left you in that lockbox will. Isn't that correct?
Correct.
You are suing to have everything in your dad's estate go to you, right?
Objection, Your Honor. Renewing my objection under 403. Cam Donaldson is not asking for anything. That determination is going to be left up to the jury.
Would you like my
Do you have a response? Yes.
Yes, Your Honor. First, if Your Honor would find it appropriate, we have no issue impeaching Mr. Donaldson with his prior testimony that he is very specifically here for all of these damages. Additionally, part of plaintiff's element that they have to prove of wrongful death is that Cam Donaldson was injured by the defendant, and specifically those damages as part of plaintiff's claim is something that they have to plead. We're not asserting that this is what the jury should give Cam Donaldson. Instead, we're asserting that this is what Mr. Donaldson himself is asking for based on his prior statements.
I'm going to overrule the objection for much the same reason that I did earlier, even though I think that you're on to something with the 403 objection. So I'll allow them, given the fact that we've proceeded down this path, I'm going to allow them to complete this course.
Mr. Donaldson, you're suing. Mr. Donaldson,
Sorry, I think you may proceed.
Thank you, Your Honor. Mr. Donaldson, you're here asking for everything from your dad's estate to go to you. That's your request, right?
That would be nice, but again, that's not my determination.
Mr. Donaldson, is it your statement here today that you are not asking the jury for the deed, the life insurance, or your dad's $5 million estate?
As my lawyer said, I believe that's a determination for the jury.
We'll move on, Mr. Donaldson. I don't have any other questions from this demonstrative for you. Mr. Donaldson, you testified in direct examination about your close relationship with your father.
Correct.
And you hired a private investigator in this case, right?
Yes.
But you didn't hire a private investigator until you didn't hire him one day later, did you?
I did not.
You didn't hire the private investigator a week after your dad disappeared?
Correct.
Or a year after your dad disappeared?
I hired Mr. Pride when Karen petitioned to have my father declared legally dead.
You hired the detective 5 years after your dad's disappearance, right?
Correct.
And that's when you found out that you were going to be losing your inheritance, isn't it?
Yes.
Because the truth is, Mr. Donaldson, you have zero firsthand personal knowledge that you saw Miss Basha do anything to Lou Donaldson. Isn't that right?
I was not there. Correct.
Well, thank you. Pass the witness.
Can you redirect?
None, Your Honor.
Did you say none?
Yes, none, Your Honor.
All right. May this witness be excused from the witness stand? I think the answer is yes. We don't have any more testimony. Obviously, you'll want to stick around.
Thank you.
Does the plaintiff have any other witnesses it wishes to call?
Yes, Your Honor. At this time, the plaintiff calls Mr. Taylor Pride to the stand.
And you may proceed when you are ready.
Good afternoon, Mr. Pride. Could you please introduce yourself to the members of the jury, spelling your last name for the record?
Good morning. My name is Taylor Pride, Pride.
Mr. Pride, where do you live?
I live in Statesville.
What do you do for work?
Currently, I run my own private investigations firm, and within that firm, I'm a private investigator.
Were you hired to conduct a forgery investigation in today's case?
I was, yes. I was hired by Mr. Cam Donaldson.
Do you know who Karen Baja is?
I do. Ms. Baja is the defendant in today's case.
Do you see Karen Baja in the courtroom here today?
I do. She is at defense counsel with the inactive Zoom box.
Let the record reflect this witness has identified the defendant as the witness with the inactive Zoom box.
It shall reflect.
Mr. Pride, did you work anywhere else before starting your own private investigating firm?
I did, yes. Long before I worked as a private investigator, I worked for the Pioneer Police Department.
What was your job at the Pioneer Police Department?
So I originally started out as a patrol officer, and I worked in that capacity for a couple of years until I was hired as a detective, and I worked as a detective at the Pioneer Police Department for about 16 years.
During those 16 years as a detective, did you ever investigate any forgery cases?
I did, yes. For 6 of those 16 years, I was part of the economic crime unit. So as part of my duties there, I investigated a number of forgeries.
Does investigating forgery cases involve any sort of special training?
It does, and I'm specially trained in specifically handwriting analysis and document examination.
Could you walk us through the training process you went through for forgery investigations?
Yes, so I initially attended seminars from the American Association of Handwriting Analysts, and then I also gained the knowledge to take a certification from the American Board of Forensic Document Examiners. And that's the basic way that you're qualified in this particular field.
Have you been certified ever since?
I have, yes. I keep up to date with my certifications, and as part of my private investigation firm, I make sure that I have continuing education on all current methods and practices.
Now, Mr. Pride, have you ever testified before today regarding a forgery investigation you've conducted?
I have, yes. I've testified 15 times for the plaintiff, for defense, and in civil and criminal cases.
And were you qualified as an expert in those cases?
I was. I've been qualified as an expert in handwriting analysis and document examination.
Your Honor, at this time, I tender this witness as an expert in the field of handwriting analysis and forensic document examination.
Is there any objection to this tender?
No objection to this witness being tendered as a handwriting expert in forgery document analysis only, Your Honor.
Okay, then you may continue.
Mr. Pride, before we get to the facts of this case, I want you to just walk us through the process you go through in forgery investigations. So what's the first step in a forensic document examination?
The first step in a document examination is to collect samples of a particular person's handwriting. So basically that's just known writing samples of your target author.
And then after you collect these samples, what's the second step in the process?
After we collect the samples, we compare them to each other. We look for similarities in things like the curves of the letters, the strokes, the number of times someone picks up their pen, embellishments, capitalization, things like that. And we try to build a profile within the known samples so we have a good idea of what this person's handwriting generally looks like.
After you identify these handwriting characteristics, what is the third step in your process?
So after identifying the characteristics, we take what we call our target document, and that's the document that's allegedly a forgery, and we compare the handwriting profile of the known samples to the alleged forgery, and we try to determine if the document that we're looking at is a true copy or a forged copy.
Aside from this three-step process you just mentioned, is there anything else that's commonly looked at in your field as part of the forensic document examination?
Yes, so there is only so much that you can get from simply looking at a person's handwriting. So it's important for us to look at the surrounding circumstances and the context around a document, and we bring that into our analysis to decide on our final determination.
Your Honor, at this time, I want to object to make sure it's clear that this witness was tendered as a handwriting and forensic document examiner only. He may testify to facts regarding his examination, but he may not testify to any sort of conclusions regarding the investigation.
I apologize. What was the specific question just now that occurred? Are you objecting to actual testimony that just occurred?
No, Your Honor. I am anticipating. May I approach constructively outside of the presence of the jury?
You may.
I'm anticipating, based on the question of regarding his actual investigation into how he determined whether or not this will was an alleged forgery, the conclusions he came to in that case should be excluded because he was not tendered as an expert in investigations. He was tendered as an expert only as a forensic document examiner and handwriting specialist. So any facts that he through his course of investigation is fine for testimony, but any sort of conclusions he may not share with the jury.
Do we have any response to this objection?
Yes, Your Honor. The only conclusion this expert is going to make is regarding the validity of the signature on the will, and any facts throughout this testimony regarding the surrounding circumstances are facts that go into his conclusion of the forgery itself. He will not be making a conclusion regarding an investigation of a disappearance.
Okay. I'm not certain that we have an actual disagreement then. What I am going to I'm going to withhold ruling right now. We're going to see how the testimony develops. I will say, certainly as an expert in handwriting analysis, he is qualified to testify about the steps he takes to obtain samples and things of that nature. I believe that's important information for him to be able to cover. So I'll withhold ruling right now. We'll continue, and then if we think we have an actual dispute, please feel free to raise the objection again.
Yes, Your Honor. Mr. Pride, just for clarification, aside from this three-step process you just mentioned, is there anything else that is commonly looked at in your field as part of the forensic document examination?
Yes. So as I said, there's only so much that you can get from just looking at two pieces of a person's handwriting. So we also bring in the outside context. And for example, in the case of a will, we speak to the witnesses of the will and bring in those pieces as part of our investigation into the legitimacy of a document.
And Mr. Pride, I'd like to turn to the facts of this case. Is that three-step process you just mentioned, along with the surrounding circumstances you look at, the same process you went through in analyzing this forgery investigation?
Yes, it is.
So for the first step, where you mentioned that you collect samples of the author, were you able to do that in this case?
I was able to collect 3 samples. I was able to collect Mr. Lou Donaldson's driver's license signature, a signature that he made on restraining order paperwork, and a note that he had written to his son.
In your field, is there a specific number of samples that need to be collected in this process?
There's no specific number. You just need a few, just enough to be able to reliably build your profile.
So were the samples that you collected in this case sufficient for your analysis?
Yes, they're more than enough.
Now, after collecting these samples, you mentioned that the second step is to identify the handwriting characteristics. Were you able to do that in this case?
I was, yes. I was able to go through and just looking at the differences in the way Mr. Donaldson loops certain letters, how much intent he puts on particular letters when he's making a signature. I was able to build a pretty decent profile of his writing.
Would showing you the signature on the temporary restraining order that you looked at assist you in explaining to the members of the jury what you found when you were identifying Mr. Donaldson's handwriting characteristics?
It would, yes.
Directing opposing counsel to what has been date stamped as 0016. Your Honor, we just intend to use this as a demonstrative and zoom in to the signature on the TRO. I'm just making sure that's okay with Your Honor and counsel, considering your ruling.
Is there any objection to him using the signature off of the restraining order?
Your Honor, the only thing we request is before they publish to the jury, they have already zoomed in only the signature, so the jury cannot see any other kind of content within the document.
Absolutely.
Certainly, and that seems fair. What I will say is, due to the nature of our forum here, we're going to assume that it has effectively been redacted, okay? And then if we do glimpse it, I'm going to instruct the jury that they are to pretend they didn't see it, okay?
Yes, sir. Now, Mr. Pride, could you please turn to what has been bait stamped as 0016?
Yes,
Do you recognize what has been bait stamped as 0016?
I do, yes. This is the copy of the restraining order.
Ms. Fagan, could you please publish? Thank you. Mr. Pride, looking at the signature here on the temporary restraining order paperwork you looked at during your investigation, explain to us what handwriting characteristics of Mr. Lou Donaldson did you identify?
Yeah, so the first things that you look at, the most obvious things I would say is that you can tell that Mr. Donaldson, it's a smooth signature. There's no quivering or shakiness in his hand. You can also see that he rarely lifts his pen from the page. And then we also look at things just like, for example, this first L, the top loop is smaller than the bottom loop. And for example, the second O in the name Donaldson, we call that a lazy letter because he didn't write it out all the way. And besides that, just the capitalization pretty much across the board is pretty standard. So it's those kind of things that we look at when building someone's profile.
Sure. Now, you mentioned that after identifying the handwriting characteristics of the author, your next step in your process is to compare the handwriting characteristics to the document in question. Were you able to do that in this case?
I was, yes.
And would showing you the will in question assist you in explaining to the members of the jury what you found when comparing the documents in your analysis?
It would, yes.
directing opposing counsel to what has already been entered into evidence as Plaintiff's Exhibit 3. Mr. Pride, could you please turn to what has already been entered into evidence as Plaintiff's Exhibit 3?
Yes, I can.
Now, Ms. Fagan, could we please publish the exhibit, please? Now, Mr. Pride, looking at the signature in question here, what differences did you find from this signature compared to the signature we just looked at before?
I apologize. My screen froze for a second. Can you ask your question?
That's okay, sure. My question was, looking at the signature here, could you explain to us what differences you found when comparing this signature to the signature we just looked at on the temporary restraining order paperwork?
Yes. So the differences I found, the most striking one to me was the fact that you can tell in this particular signature, the author was lifting their pen and putting it down a lot more than in the samples I had. If you look just within the D, in the sample signature, the author only picks up his pen twice, but in this signature, the author picked up their pen 3 times. There's also, you can see a shakiness in the hand of the author on this will. And furthermore, the letters are all spelled out very exactly. There are no lazy letters that you kind of skip over when you write your signature often. And so it was these things that all indicated to me that someone writing this signature was likely copying down a signature and not writing their own.
Now, Mr. Pride, aside from this 3-step analysis you just mentioned, you also said that you look at the surrounding circumstances of the document in question. Were you able to do that in this case?
I was, yes.
And what, if anything, did you find when looking at the surrounding circumstances?
So the first thing I noticed was some irregularities in the wording of the will specifically.
Could you explain what you mean by irregularities?
Yes, so there was the language in the will that said, should I die or disappear? And, you know, I do this work a lot. I've looked at hundreds of wills over the course of my career, and that phrasing, specifically the disappear part of it, I haven't seen in a single will.
Mr. Pride, do you know who Samantha Lane is?
I do. She was one of the witnesses, or alleged witnesses to the will.
Did you ever get into contact with Samantha Lane?
I did. I was able to speak with Samantha Lane.
When you spoke with her, what did she say?
Objection, Your Honor, to hearsay.
We have a response to hearsay.
Yes, Your Honor. Pursuant to Federal Rule of Evidence 703, while this statement would otherwise be inadmissible, it is admissible to show what this witness, this expert witness, looked at in his investigation to come to his conclusion. The probative value of it is substantially outweighed by the danger of unfair prejudice, and that it will help explain to the members of the jury how exactly he got to his conclusion in this case.
I'm going to overrule the objection. I think that this witness as an expert can, in fact, rely on hearsay in forming his opinion. And although I don't know exactly the testimony we're about to hear, given that this is a witness to the will's execution, I do find that it passes the reverse 403 test.
Your Honor, may I respectfully, constructively approach the bench?
You may.
Your Honor, the reason I raised the hearsay objection is because 703 does allow experts to testify based on the hearsay of their conclusions. 703 does not allow experts to admit the statements that they based on those conclusions. So while he may testify his conclusion that he learned from the hearsay itself is actually not admissible under 703, and that's why I raised my hearsay objection.
Certainly, I understand the objection. It's fair. I'm going to overrule it at this time.
Thank you.
Mr. Pride, what did Miss Lane tell you?
Miss Lane indicated to me that she actually never witnessed the will, and that she didn't sign it as a witness, and that essentially her name being down as a witness for that will was just incorrect.
Now, after speaking to Miss Lane, what was the next step in your investigation of the surrounding circumstances?
The final step in my investigation was to look at some background information about Mr. Lou Donaldson, and as a part of that, I got a hold of some of his bank records.
And what did you find when you looked at those bank records?
When I looked at those bank records, it became clear to me that on August 17th, the same day that he disappeared, it looked like that was the last day he ever spent any money out of his bank accounts.
Mr. Pride, were you ever able to get into contact with Mr. Donaldson throughout your investigation?
No, I was never able to get in contact with him.
Now, did you come to a conclusion in this case regarding the validity of the signature on the will?
Yes. So based on the surrounding circumstances, the fact that Mr. Donaldson seems to have disappeared, the fact that Miss Lane, in fact, did not witness the signing of this will, as well as my handwriting analysis, which showed that the signature by Mr. Donaldson on the will was very likely a forgery, I came to the conclusion that the entire will itself is a forgery and is illegitimate.
No further questions, Your Honor.
Do we have a cross-examination of this witness?
Yes, Your Honor. And Mr. Pride, before we begin, I just want to apologize. I have some speaker issues. Sometimes it flickers in and out. So if you answer a question and I'm not responding, that's why. And I may ask you to repeat your answer. I'll let you know, though, if I had issues hearing you. And if you have any issues hearing me, please let me know, okay?
No problem. That sounds great.
Now, Mr. Pride, you were hired by Cam Donaldson, right?
I was, yes.
And he hired you 5 years after his father disappeared.
That's correct.
And he hired you to look into these forged will claims.
That's correct.
And the only information you had was what was provided to you 5 years later.
Yes, what was provided to me, and then, as I mentioned, I did my own investigation as well.
So, Mr. Pride, I want to talk to you a little bit about your investigation into the handwriting samples. You said you collected samples, correct?
Correct.
You collected the driver license sample?
Correct.
But that wasn't the original driver's license handwriting.
No, it was a copy of his handwriting.
It was a copy. And you did not collect the original of the temporary restraining order, correct?
No, again, I received copies.
But you did have the original of an alleged note he wrote his daughter, right?
Correct.
Or his son, excuse me. Now, Mr. Pride, I think we can both agree that not all signatures are the same, right?
Yes, there are usually slight variations between a person's signature, even if we know that it belonged to one person.
Right, because those variations can occur because of a variety of factors. Yes?
Yes, things like age, health, whether you're writing on a steady surface, the type of pen you're using, that kind of thing.
But if every signature looked exactly the same, that would be a forgery, wouldn't it?
I'm not sure what you mean.
Well, let me make it a little bit more clear. What I'm saying is if each signature looked identical, that would indicate a forgery, right?
Not necessarily. We can find commonalities between signatures. And oftentimes when people do sign a document, you sign your signature so much that they look very similar from point to point. But as I said, there are usually slight variations.
Mr. Pratt, I want to make sure I understand your testimony here today. So your testimony here today is that identical signatures on individual documents are always indications that they are genuine?
I would say probably 99% of the time, unless someone was very good at forging a signature. If signatures were almost identical, they would be accurate to match each other.
Mr. Pride, you talked a little bit about the actual wording in the will. I believe it was the die or disappear language.
Correct.
And you said you've never seen it before.
That's correct, yes.
But unusual language doesn't make a will forgery, does
it? No, not the unusual language alone. It's the collection of everything that we look at.
Right, but just writing the word disappeared doesn't make a will a forgery, correct?
Objection, Your Honor, asked and answered.
It's a good objection. I'm going to let her continue with her cross-examination, but good objection.
Yes, Your Honor.
And Mr. Pride, I just want to be clear. Having the word disappeared on a will, it doesn't make it a forgery, right?
It's a piece of the puzzle, but not the whole puzzle.
No further questions.
Do we have any redirect?
No redirect, Your Honor.
All right, this witness is excused. Does the plaintiff have any further witnesses it wishes to call at this time?
No, Your Honor, at this time, the plaintiff rests its case in chief.
All right. How are we doing in terms of time? Can I get a time check?
Your Honor, a moment to confer with the other timekeeper to make sure that we have the same.
Sure, absolutely. While you do that, in your other rounds that you've done, has there typically been a short recess after the presentation of the plaintiff's case in chief?
There has, Your Honor. We usually would take a 5-minute recess after the plaintiff's case in chief and then before closings as well.
Would everybody like to take a brief 5-minute recess?
Yes, Your Honor.
Yes, Your Honor.
All right. So let's take a 5-minute recess. It's 10:49 Mountain Standard Time for me. Probably is different for you depending on where you are. Let's come back at 55 after, okay?
Yes, Your Honor.
can I get a check-in from the plaintiff regarding if all of your witnesses and your counsel, your co-counsel is present?
Yes, Your Honor, everyone's here.
What about for the defense?
Yes, Your Honor, everyone's here.
All right. Is the defense prepared to, does it want to present a case?
Yes, Your Honor, but first we would like to move for a judgment as a matter of law under Federal Rules of Civil Procedure 50. Plaintiff has failed to provide legally sufficient evidence for at least 2 of their claims that they must. Plaintiff has failed to prove that Karen Baja intentionally or recklessly caused the wrongful death of Lou Donaldson, and the plaintiff has also failed to prove that Karen Baja has been the cause of the harm that occurred to Cam Donaldson.
Do we have a response to the objection or to the motion?
Yes, Your Honor. Opposing counsel's motion should be denied. Viewing the evidence in the light most favorable to the non-moving party, that being the plaintiff, as this court is required to do, a reasonable jury could conclude by preponderance of the evidence that we have fulfilled every element of the claim brought forth here today. The plaintiff presented 2 witnesses today, both of which supplied direct and circumstantial evidence to fulfill those elements. We heard from Cam Donaldson today, who testified as to the defendant's motive in this case for money, and the fact that he saw the defendant on the same weekend that Mr. Donaldson disappeared. We also heard from Mr. Pride today, who testified that he concluded that the will was forged, which would be the intentional act leading to the death. For those reasons, Your Honor, the opposing counsel's motion should be denied.
I'm going to deny the motion. As the standard has been correctly recited, I have to view the evidence in the light most favorable to the non-moving party. And I do find that a reasonable jury could find that every element has been met by a preponderance of the evidence. So the motion will be denied. Would the defense like to proceed now to its case?
Yes, Your Honor, we would. And we would call our first witness, Karen Baja.
You may proceed when you're ready.
Thank you, Your Honor. Ms. Baja, I said this previously to Mr. Pride, but sometimes I do have some speaker issues, so if you don't respond right now. So if I don't respond after you answer a question, I apologize and may ask you to repeat it. Is that okay?
Yes, that's fine.
I will let you know, though, if it's a speaker issue. Now,
Thank you.
Now, Ms. Baja, you and I have gotten to know each other really well, but would you turn and introduce yourself to the jury?
Hi, my name is Karen Baja.
Where do you live, Ms. Baja?
I live right here in Pioneer, Statesville.
What do you do for a living?
I have the best job in the world. I run a big cat sanctuary. It's called Wild Wildlife.
I'm turning the court's and opposing counsel's attention to what was previously bait stamped as 009. Ms. Baja, what are you looking at on your screen?
I'm looking at, it's a picture of our favorite cat at the sanctuary, Tara the tiger.
How do you know that this is Tara?
How could I not? I see her every day. The stripes, the specific pattern, her ears, that's Tara.
When was this photo, around when was this photo taken?
This photo was taken about a year ago.
At this time, plaintiff is constructively tendering defense is constructively tendering what would be marked as Defense Exhibit A to opposing counsel, and defense offers Exhibit A into evidence.
Is there any objection to the admittance of Exhibit A?
Yes, Your Honor. While I do understand this is part of the background information portion of the direct, I don't see the relevance in entering this exhibit.
Is there a response to the relevance objection?
Yes, Your Honor, we're here today, and one of the things that plaintiff has made clear in their case in chief is that they're here to discuss wild wildlife. Now, the photo that is depicted in what is marked bait stamp 0009 is a tiger that is part of Wild Wildlife Sanctuary. And if I may constructively approach outside the presence of the jury, Your Honor.
Absolutely. We'll just consider that all of our sidebars are outside the presence of the jury.
I just wanted to let you know, Ms. Baja's testimony is only going to regards about what it takes to run Wild Wildlife and about her jobs there. This photo is highly relevant towards showing showing the kind of work that they do for this sanctuary that has been in dispute the entirety of this case.
I'm going to overrule the objection. I agree that this exhibit likely tends to have little relevance. However, as I'm certain the parties know, that's a pretty low standard. And given what was proffered in opening statements, my understanding is we're probably going to have some testimony about the tigers, and this has a tendency to help the jury picture what we're talking about. So I'll overrule the objection.
Yes, Your Honor.
Your Honor, may I get a ruling as to Defense Exhibit A being admitted into evidence?
It will be received into evidence.
At this time, may defense publish Exhibit A?
It may.
Ms. Aja, I believe you said while we were just talking that this is Tara the tiger. I've never cared for large cats. Would you explain to the jury what that's like?
I mean, it's a 24-hour job. These aren't house cats. As you can see, they're big animals. They take a lot of land to run around and exercise, socialize, and it takes a lot to feed them too.
How did you get started with working with large cats?
So when I met my husband, Lou, we started Wild Wildlife Sanctuary together. We realized we had this shared passion for these majestic creatures, and that's one of the reasons we fell in love.
Ms. Baja, I want to talk to you now a little bit about your husband, Lou. When did the two of you meet?
We met in 2001.
What was life like with Lou?
You know, no marriage is perfect, but it was built on this foundation of love that went a lot deeper than just each other. It went towards our for cats, and we had our struggles, we had our arguments, just like every couple. I know that the temporary restraining order, it doesn't look good, but we had this solid foundation and we were working on things.
Ms. Baja, were you and Mr. Donaldson still legally married before he disappeared?
Yes, we were.
I want to talk to you now about the night that Lou Donaldson disappeared. Do you remember the night of August 17th, 2012?
I do.
What were you doing on that night?
So a couple of days before that night, one of our tigers had given birth to cubs. So, the tiger did not rejected the cubs. It was my job to go in and make sure that they were taken care of, warm, fed. They're like little babies. They have their own time schedules and they just will cry until they get what they want.
Were you able to give them what they wanted tonight?
Objection, relevance, Your Honor.
Do we have a response to the relevance objection?
Yes, Your Honor. We're here today because Ms. Baja is being accused in this wrongful death lawsuit. Now, every party seems to have agreed that the day Mr. Donaldson disappeared was either August 17th or the early morning hours of August 18th. Ms. Baja is just explaining what she was doing that day, so it is highly relevant. And under 403, its probative value substantially outweighs any sort of prejudicial effect.
I'm going to overrule the objection, and I'll allow this testimony to be developed on that basis.
Ms. Baja, I believe I was asking you, were you able to provide these kittens what they needed?
I was up until, 3 a.m. on the early morning of August 18th. I had run out of formula, and everything was so hectic. I just hopped in my car and ran to the store, but I left my cell phone.
Were you able to get the formula?
I was, but, these things just happen in threes. My car broke down on the way back to my house full of groceries.
So how did you get home?
So my brother is a sheriff's deputy. I knew he'd be on duty that night, so I called him and he came and checked out my car and then took me home.
Now, Ms. Baja, I want to talk to you about what occurred on August 18th of 2017. What did you do that day?
That was the day that I had Lou declared legally dead.
Why?
You wait for somebody to come home, days, weeks. It turned into half a decade. I was just hoping, we could get some closure, and I needed a way to keep wildlife running.
When you said you needed a way to keep wildlife running, how would declaring your husband legally dead help you do that?
It allowed me to probate his will and to file for his life insurance policy. So that money could all go towards wildlife.
Ms. Baja, I now want to talk to you about your relationship with the plaintiff. How is your relationship with the plaintiff?
Well, I don't trust Cam. And I mean, everyone heard him come up on the stand today and say that he didn't think that I loved his father because I was too poor or too young. And then he brings this lawsuit against me. Yeah, I have reason not to trust Cam.
Ms. Baja, I know you were in the courtroom earlier and we heard talks about you and going to wildlife on the early morning hours of August 19th, 2020. Were you at wildlife that day?
I was. I don't agree with Cam's characterization of it as a break-in when I'm a co-owner, but I was there.
Do you need any sort of permission to go to the office?
No, I don't. I co-own it. At the time, I co-owned it. So there's no break-in. There's no need to get permission from my husband. We were partners.
Do you need permission from anyone, including the plaintiff, to go to the office?
No, not Cam. Cam was Blue's assistant. There was no reason for me to tell Cam why I was going there or when. Also, there's tigers there that need 24-hour care. If I'm going to go to the office to take care of them, that's because they need care.
Ms. Baja, why did you go to the office that day?
It had been 36 hours since anybody had seen Lou, and there was no indication that he was in the house or around. I started getting nervous, and again, I don't trust Cam. I never have. So I went to the office to make sure everything was all right.
Ms. Baja, you mentioned that there was no indication that Lou Donaldson was around. Has that ever happened before?
Yes. I mean, he used to hop in his plane all the time and leave, but that's just kind of how Lou was. He would leave and just not tell anyone. He kept things very close to the chest.
Would Mr. Donaldson always file a flight plan?
No, especially in those last, couple of months that anyone saw him. His pilot's license was suspended, so he wasn't filing his flight records. He didn't want to get caught.
Finally, Ms.
Objection, I'm sorry, Your Honor. Objection to speculation to the last line, and I move to strike the fact that he did not want to get caught.
I'm going to sustain the objection at this time, and I will strike that portion of the testimony that he did not want to be caught. If foundation can be laid that there's some basis this witness actually has knowledge of that fact, we can revisit it once foundation is laid.
Ms. Baja, I just briefly want to ask you this last question here. How many planes did Mr. Donaldson have?
I don't know. He had so many planes. He didn't really tell anyone how many planes he had.
Pass the witness.
Would the plaintiff like to cross-examine this witness?
Yes, Your Honor.
You may proceed.
Ms. Baja, you benefited from Mr. Donaldson's death.
I wouldn't say that, counsel. I lost my husband.
Well, you made a lot of money after you declared him dead, right?
Again, made a lot of money? That's not how I see it.
Well, you did receive a lot of money after you declared Mr. Donaldson dead, isn't that right?
Yes.
Because after you had him declared dead, you inherited his entire estate?
That's right.
And that estate was worth $5 million?
Yes.
Not only that, but you also got an insurance payout too, right?
That's right.
And that was also worth $5 million.
That's correct.
So you made a total of $10 million after declaring Mr. Donaldson dead.
Counsel, I didn't make anything.
You did receive that money after declaring him dead, right?
Yes.
And just to be clear, if Mr. Donaldson was still alive, you would not have gotten that money, right?
No, Lou would be able to, his assets would still be with him and he'd continue running Wild Wildlife.
Before you met Mr. Donaldson, you didn't have a lot of money, did you?
No, I didn't.
You came from a poor upbringing?
That's right.
Objection to improper character evidence.
Can you further expound on your improper character evidence objection?
Yes, Your Honor. There is absolutely no reason that it matters what Ms. Baja had or did not have when she was younger in regards to the lawsuit that we're here today for, which is a wrongful death claim, not whether or not Ms. Baja was rich or poor.
Can I get a response to the objection?
Yes, Your Honor. This isn't character evidence at all. We're not using this to show that she did something in the past, so she must have done something in the future. We're not using this to show propensity, just going to the motive of the defendant.
I'm going to overrule the objection.
So, Ms. Baja, you did come from a poor upbringing?
That's right.
But when you met Mr. Donaldson, that changed, right?
It didn't change where I came from. No, counsel.
No, your lifestyle changed once you met Mr. Donaldson, correct?
That's right.
Because he was very wealthy.
Yes. He'd worked very hard for his money.
And you were very happy being married to Mr. Donaldson, right?
I loved Lou. Yeah.
But your marriage, it wasn't perfect, was it?
No marriages.
Well, I'm just talking about your marriage. It wasn't perfect, right?
Right.
Because it had certain problems.
Right.
And those problems got so bad that Mr. Donaldson filed a temporary restraining order against you.
I can't say why Lou filed the temporary restraining order. I can tell you that it was denied, and we continued working through things for the 2 months leading up before he was gone.
That restraining order, it looks bad, doesn't it?
It does, yeah.
And isn't it true that aside from this temporary restraining order request, he asked you for a divorce at some point as well?
We had been talking about it, yes.
But you didn't want that, did you?
We were working through things. We were just trying to see where we were at. Again, we had such a strong love foundation that we were working through it.
You did not want a divorce from Mr. Donaldson, correct?
At what point, counsel?
Ever.
I can't say that I had definitively said that I want a divorce.
I'm not asking you what you said. I'm just, to clarify, you did not want to be divorced from the husband that you said you love so much, correct?
I hadn't reached that extreme, no, counsel.
Now, August 18th, 2012, you remember that day, right?
August 18th, 2012, yes.
You were taking care of the Cubs that morning?
Yes.
But at some point you left to go to the store.
Right, I ran out of formula.
And you forgot your cell phone?
Yes.
And then your car broke down.
Right.
And this all happened at 3 a.m.
Yes.
So because you didn't have your cell phone on you, you decided to flag down a random stranger passing by?
I'm just lucky that somebody was even around for me to borrow their phone.
So you did flag down some random stranger, correct?
Yes.
And you asked to use this random person's phone?
Yes.
But Ms. Baja, you can't tell us if this random person that stopped on the side of the road to help you out at 3 a.m. was a male, can you?
I mean, it's been at this point, it's been 8 years, counsel. I don't really remember.
I'm sure you don't remember if it was a female.
No.
You can't tell us an article of clothing they were wearing, maybe.
It was dark. It's not like they had lights on inside of their car, counsel.
You can't tell us what color the car was?
It's been 8 years. No, I can't.
You can't tell us what kind of cell phone you used?
That wasn't really what I was trying to pay attention to at that time, so no.
And of course, you were all by yourself when this happened, right?
Well, there was the person whose phone I was borrowing, so no, I wasn't by myself.
Besides that person, it was just you and this random person, correct?
Right. I mean, it was 3 a.m.
Now, Ms. Baja, after this random person stops, you decide to make a call.
Yes.
And being that it was 3 a.m. with your car broken down, you wanted to call someone that you trusted.
Right.
Someone that you loved.
Yes.
But you didn't call your husband, did you?
Counsel, it was 3 in the morning, and I wasn't even sure if he was home, but I knew that my brother was out on patrol already, so that's why I called him.
Well, you say that you weren't sure if he was home, but you didn't even try to call Mr. Donaldson, did you?
No, I already knew who was out and about and driving around and awake, so that's who I called.
You called your brother Carl, right?
Yeah.
Carl's a deputy sheriff
That's right.
in this county.
Yes.
So that means your brother works for the same police department that investigated Mr. Donaldson's disappearance?
That's right. He recused himself from the investigation.
He's a part of the same police department that would have arrested you had you been charged with anything, right?
Objection asked and answered.
Their response to asked and answered.
It was a different question, Your Honor. First, I asked if he was part of the same police department that investigated Mr. Donaldson's murder. Then I asked if he's a part of the same police department that would have arrested you had you been charged with anything.
It's a fair objection in that it's pretty close, but I'm going to overrule it.
So, Ms. Baja, your brother does work for the same police department that would have arrested you had you been charged with anything.
Yeah, he works for the same department that would have arrested anyone who they suspected.
Sure. Now, it's true that a week after August 18th, you went to go pick up Mr. Donaldson's van at an airstrip
That's right.
with your brother Carl,
Yes, we caravanned.
and the police released the van to you right away. Isn't that right?
I don't recall right away. Right away in relation to what, counsel?
I'll ask another question. They did not examine that van before releasing it to you. Isn't that right?
I'm not sure what they did or didn't do.
Inside that van was Mr. Donaldson's keys
Yes,
and his glasses.
yes.
And because you were so close to Mr. Donaldson, you would of course know that he never flew without those glasses, right?
Counsel, I don't know how many pairs of glasses he had. I knew that he needed glasses.
Ms. Baja, you have a meat grinder at Wild Wildlife, don't you?
Yes, I do.
And you of course know how this meat grinder works
Yes.
because you've used it before.
Objection, Your Honor. I was going to see what was happening here. This is no relevance of whether or not Wild Wildlife, a big cat sanctuary, has a meat grinder.
I'm going to overrule the objection.
Ms. Baja, you know how this meat grinder works because you've used it before, correct?
I tried to feed the cats.
That meat grinder, it grinds up large pieces of meat into little pieces of meat, correct?
Right.
And then you feed that meat to the cats.
Yes.
Now, after that meat goes through the meat grinder, it's all mixed up together, isn't it?
Your Honor, objection to the relevance of what happens with meat after it goes through a meat grinder.
The response to the relevance objection.
Yes, Your Honor. It's part of the plaintiff's theory in this case that the defendant killed Mr. Donaldson by putting him in the meat grinder and feeding him to the cats.
I'm going to overrule the objection.
Ms. Baja, after this meat goes through the meat grinder, it's all mixed in together into different chunks, right?
I don't know what mixed. It depends on like what different pieces of meat you put in, or if you're just putting one piece of meat in. If it's just one piece, like from a cow or something, then it's not really mixed.
It grinds up meat into little chunks, isn't that right?
Yes.
Okay, and that meat grinder is very large, right?
I mean, it's average meat grinder size.
To you, that meat grinder is very large, right?
I mean, it's bigger than I am.
Ms. Baja, okay, bigger than you are as a human being. So, according to you, it takes 2 people to use this meat grinder, right?
That's right.
Your brother Carl drove you back to the Cubs on August 18th, 2012?
That's right. He drove up with me in the car. I hopped out and went inside with the formula.
You and your brother, that's 2 people, isn't it?
Yes, counsel, that's 2 people.
And Ms. Baja, your husband disappeared that very same weekend, didn't he?
That general weekend, I didn't see him.
that was the last weekend that Mr. Donaldson was ever seen alive by anyone, correct?
I don't know about anyone that I've talked to. Yes.
And you were testifying that Mr. Donaldson would go on trips every now and then?
Yeah, he would just hop in his plane and go. He loved to fly.
But he would always come back. True?
Yeah, that's true. Yeah.
Nothing further, Your Honor.
Is there any redirect to this witness?
I only have one question, Ms. Baja. Did you kill your husband?
No, I didn't kill Lou.
No further questions, Your Honor. May this witness step down?
Absolutely. Does the defense have any other witnesses you would like to call at this time?
Yes, Your Honor. At this time, we are going to call, by way of reading in his deposition testimony, Carl Bannister. My co-counsel is going to be assisting me by reading out the answers on that testimony as I read out the questions. And additionally, the parts of the testimony that we read out will be shown on the screen from the transcript that the parties have stipulated to as authentic, just to help the jury follow along.
Is there any objection to that practice?
No objection, Your Honor. However, the plaintiff does request that we be able to read in another portion of that same deposition in rebuttal.
Certainly, you'll be able to do that. Okay, you may proceed.
Yes, Your Honor. And just to clarify, do we still reserve our right to object to opposing counsel's testimony depending on what lines they're reading in during cross-examination?
It's my understanding that yes, you'll be able to object. If anybody can point me to a court rule or a stipulation saying otherwise, please do. But otherwise, yes, you'll be able to raise objections.
Directing the court's attention to page 1, lines 1 through 8 and 13 through 14. Question. Hello, Deputy Bannister. Would you please state your name and spell it for the record?
Answer. Deputy Carl Bannister. CarlBannister.
Question. What do you do for a living?
Answer. I am a deputy sheriff for Pioneer County, Statesville.
Question. How long have you worked as a deputy sheriff?
Answer. I was first hired out of the academy in May of 2005 by Pioneer County. I have worked there for over 15 years now.
Question. How are you involved in this case?
Answer. Well, I'm not involved in this case, but I guess you can say I am here because my sister is Karen Basha.
Question. Okay, let me ask you about the night, early morning hours of August 18, 2012. Do you remember that pre-dawn time?
Answer. Yes, I do.
Directing the court's attention to page 1, line 17 through page 2, line 3. Question. What do you remember about that time?
Answer. Well, it was a normal sort of shift. I was just answering patrol calls when I got a personal call from Karen.
Question. When was that?
Answer. It was close to 3:00 a.m. She had gone out to the grocery store late at night in order to get some milk or something for some newborn tiger cubs. She had car trouble and needed a ride home as soon as possible to get back to the cubs.
Question. Did you go to pick her up?
Answer. Yes, I did.
Directing the court's attention to page 2, lines 16 through 21. Question. How was she doing when you met up with her?
Answer. She was fine. She was just really concerned about those newborn cubs and wanted to get back to them as soon as possible.
Question. Did you drive her back to her home?
Answer. I first took a look at her car and it would not start. So I made sure it was safe by the side of the road and then took her home. We got to her house around 3:45 a.m., definitely before 4:00 a.m.
Question. Do you know if Lou Donaldson was home that night?
Answer. No, we didn't talk about him. She was just focused on those tiger cubs and kept talking about them, how cute they were, how they were doing, stuff like that. She just loves animals, especially big cats.
Directing the court's attention to page 3, lines 11 through 14. Question. Deputy Bannister, how was your relationship with Mr. Donaldson?
Answer. It was fine. He did some great things for my sister, helping her find her passion for animals, big cats in particular, but he could be difficult.
Question, what do you mean by that?
Answer, well, he was moody at times and suspicious of people. He seemed paranoid. He would go off to Central America for extended periods of times and not want to talk about what he was doing down there.
Lastly, directing the court's attention to page 4, lines 8 through 9. Question, did you have a chance to view any evidence or look at the reports?
Answer, no, I take my job seriously. I knew nothing of Lou's disappearance, and I wanted to keep it that way. I was walled off from the investigation, and that was fine by me.
We have no further testimony to share from this witness, Your Honor.
All right, and I'll turn to opposing counsel. You wanted to read something in, so you may proceed to do that.
Yes, Your Honor. Is it okay if I just read it in myself?
Certainly.
Okay. Directing the court and opposing counsel's attention to page 3 of Mr. Bannister's deposition, lines 5 through 13. Question, are you aware that the Pioneer Sheriff's County Office keeps tracking records for all the vehicles? Answer, sure. It is a good way to know where each deputy is located in the jurisdiction during a shift. Question, are you also aware that there is no record of your patrol vehicle moving from 3:20 in the morning until nearly 6:30 in the morning, as it was showing it was near the grocery store, close to Ms. Baja's home during that time?
We are going to object to at this time, as the answer that comes next in this transcript goes into the contents of an exhibit that have not yet been admitted. Your Honor, under the best evidence rule, this would require opposing counsel to admit this exhibit as it is available. However, opposing counsel, even if they were to admit it, we'd object to the authentication and the hearsay that is in this exhibit.
Do we have a response to the objection?
Yes, Your Honor. Pursuant to 804B4, this is a prior testimony given with the chance for cross-examination, and as such, that goes to the hearsay. And with that, we should be able to rebut the plaintiff's, the defense's reading in earlier.
Your Honor, may I clarify my objection?
Well, one moment. Is the next portion we're going to read, is it effectively a verbatim portion of some exhibit that's not been entered?
No.
Your Honor, it does state that in the answer, yes, I looked back at that in preparation. And it also states that the issue was noted in the maintenance log and replaced the next day. It does specifically state the contents that are in that exhibit. That is not yet in evidence.
Okay, do you have a response?
Yes, Your Honor. It doesn't state the full contents of what was in that exhibit. It just gives a brief overview.
Okay, I'm going to go ahead and overrule the objection. I'm going to overrule the objection for now. Please feel free to raise it again if you think we're really getting into the contents of some form that's not in evidence.
Answer, yeah, I looked back at that in preparation for this deposition, and the records show that my transponder, the device that gives the location of the patrol car, was malfunctioning, cutting in and out. The issue was noted in a maintenance log, and it was placed the next day. The second portion, directing opposing counsel and the court's attention to page 4 of Mr. Bannister's deposition, lines 10 through 13. It reads, question, were you involved in the investigation of the disappearance of Lou Donaldson? Answer, no, it would not have been appropriate. I mean, I know the detectives and investigators who looked into it. I have been working with them for years, and we are all pretty close. But I was not personally involved in the investigation.
Would you like to read anything else in, or are you finished?
I'm finished.
No, you don't have any other testimony to read in from this witness.
Okay. Does the defense have any other witnesses they'd like to call at this time?
Yes, Your Honor. At this time, the defense calls Chris Renard.
And you may proceed when you're ready.
Mr. Renard, would you please introduce yourself to the jury?
Good morning. My name is Chris Renard.
What do you do for a living?
I am a forensic document examiner and insurance investigator for Summit Life Insurance.
What exactly is a forensic document examiner?
Well, a forensic document examiner is brought in when there's a dispute about the authenticity of a document or the concern that it might be forged. What we do is we look at a document, determine whether any signatures are authentic, and also look at the totality of circumstances surrounding a document to make a final determination about whether or not we believe that this document is legitimate.
Looking at the totality of the circumstances, is that also something that you do as your job as an insurance investigator?
Yes, absolutely. It's very important when doing these sorts of investigations, especially when there's a lot of money on the line, to do a thorough job in an investigation.
What sort of background and education do you have that led you to be able to do these two document examination and investigative work?
Yeah, so I have a BA in criminology from Summit College. I also attended the Statesville Police Academy, but more importantly, I've spent 23 years as a forensic document examiner, specializing in handwriting and signature identification, fabricated documents, and altered records. 3 years of that was with the Statesville Bureau of Investigation Crime Lab as a forensic document examiner, but the bulk of that, about 20 years since the year 2000, has been at Summit Life Insurance Company as an investigator and forensic document examiner.
Do you have any specialized certifications in either one of those fields?
Yes, I'm certified by the Board of Forensic Document Examiners and the Association of Certified Fraud Specialists. And I participate in annual training workshops and continuing education related to those qualifications.
I want to discuss your methods for just a moment. When you're trying to determine if a document as a whole has been forged, what all kind of evidence do you look into?
Well, so the first step of looking at a document is going to be to examine any signatures on that document, sort of compare them to known examples of a signature of the person to determine whether the signatures are authentic. But that's not the end of the analysis. I also will talk to any witnesses who witnessed the signing of that document. If the signer is still available, I'll speak to them as well. And I also examine the text of the document.
Now, you mentioned that you sometimes look at the signature. Do you look at the analysis on the signature before you go into your analysis on all of the other circumstances?
Yes, typically the signature is where I start an investigation, and then I move on from there depending on my findings on that signature.
And what sort of things do you look for when you're comparing signatures to see if they have similarities or differences?
Yes, so there's a number of things that are that you can look at in order to determine whether a signature is the same. There's loops, strokes, the stroke direction, legibility, sort of angles and capitalization of different signatures can help to determine whether they're both signed by the same person.
Is it possible for you to make a determination on whether or not a signature is genuine just from this comparison analysis?
That depends on the specific case. Sometimes, yes. Sometimes I'll find a number of signatures for comparison, and I'm able to make a final determination there. Other times, I have to also look at the totality of the circumstances surrounding the document.
Now, are these the same methods and analyses that other experts in your field use?
Yes, they are.
Mr. Nard, did you review a will in this case belonging to Lou Donaldson?
Yes, I did.
And did you come to a conclusion as to whether or not that will was forged?
I was able to come to a conclusion, yes.
In making this conclusion, did you rely on your education, your training, and these methods that we've discussed?
Yes, I did.
Did you reach your conclusion within a reasonable degree of professional probability?
Absolutely, yes.
At this time, defense tenders Chris Renard is an expert in forensic document examination and as an insurance investigator.
Is there any objection to the tender or any request for voir dire?
No objection to tendering him as an expert in the field of document forensic examination. However, we do anticipate that Mr. Renner will be seeking to offer the opinion that the defendant did not have anything to do with Mr. Donaldson's death. And in anticipation of this testimony, we move to limit his expert opinion strictly to the analysis of Mr. Donaldson's signature and the validity of the will.
Is there any response to that request for limitation?
Yes, Your Honor. We ask this court to not grant that request for limitation as we have laid the proper predicate under Rule 702 for Mr. Renard to be qualified as both an expert in forensic document examination as well as an insurance investigator. Not only has Mr. Renard been doing this for 23 years, but he just went through the methods that he uses, looking at the totality of the circumstances, the different people that he calls about a will, the language that he looks at, and confirmed with us that these are the same methods that other experts in his field rely on in drawing his conclusion, and that these facts that he relied on as well are reasonable and are sufficient facts to reach his conclusion.
Your Honor, if I may respond.
Very briefly.
Under 702, an expert may offer an opinion in the form of a testimony, and that testimony must be based on sufficient facts and data, and that it has to be a product of reliable principles and methods. Now, in the field of forensic document examination, experts do not regularly rely upon secondhand information from unnamed contacts. That is not a reliable method used in any field. Further, Mr. Renner did not conduct a thorough investigation into the specific disappearance of Lou Donaldson, and as such, any conclusions as to Ms. Baja's role must be excluded.
I'm going to sustain the objection in part. And specifically, I think this individual is qualified as an expert. He's testified he routinely does insurance investigations. I think it's proper for him to testify about that process. But ultimately, I think the goal, as I understand his testimony, the goal of those investigations is to determine whether or not really a claim should be paid. And so he'll be allowed to offer an opinion about whether or not the claim was appropriate and should be paid. But I'm going to limit him from saying definitively and conclusively who is or who may not be responsible for someone's disappearance. Does that make sense?
Yes, Your Honor, just a quick clarification question to make sure that we don't go outside the bounds of that. Mr. Renard is going to testify that the reason that they look into these investigations is to look at the circumstances and see whether or not the defendant did in fact wrongfully kill Lou Donaldson, as that was her assignment here, to determine whether or not the insurance policy would be paid out. So as far as that conclusion was part of Mr. Renard's insurance investigation role that he was required to do as his employment.
Certainly, and I understand that, and I think that's appropriate. I think if we get to a portion where he's effectively acting as police and saying, I'm telling the jury definitively she did not kill Mr. Donaldson, I think that we would be stepping outside the bounds of his tender. Does that make sense?
Yes, Your Honor, I understand now. Thank you.
Okay.
Mr. Renard, before we get into your findings on this case, I want to discuss, how did you become involved?
So I became involved in 2017 when Ms. Baja requested a payout on Lou Donaldson's life insurance policy. I was asked to investigate and determine whether or not it was a legitimate claim and whether we should pay out that $5 million policy.
And this insurance policy by Lou Donaldson, when was this insurance policy made?
Well, this insurance policy was initially created and signed in 2005.
About how many years before Lou Donaldson disappeared was that document signed?
That's about 7 years before.
And as far as the beneficiary of Lou Donaldson's life insurance policy, from your knowledge of your company, has it always been Ms. Baja?
Yes, the beneficiary has always been Karen Baja, and that has not changed at any point throughout the life of the policy.
Mr. Renard, did Ms. Baja hire you to investigate this case?
No, not at all. I was subpoenaed to be here. I'm not being paid by Karen Baja. My only employer is Summit Life Insurance.
Do you get anything here out of saying that Ms. Baja should receive the payout from the life insurance? No, I do not. Let's start out by talking about your conclusions and your analysis of the signature on Lou Donaldson's will. Mr. Renard, you mentioned earlier that you made a comparison. Will you briefly discuss the comparison analysis that you did in this case?
Yeah, so the best way to compare signatures is and to do an initial determination is to find confirmed examples of the person's signature, things that you know were signed by that person, and then you compare those signatures to each other for similarities, and then you compare them to the signature that's in question.
Would you pull up on your screen what has been Bates marked as 007? And let me know when you have it pulled up.
Yes, I have that pulled up.
What is this document that we're looking at on the screen?
This is a signature comparison chart that I use to compare existing signatures and confirmed signatures of Lou Donaldson to the signature on his last will and testament.
So if we look in the bottom left-hand corner of this document, is that your signature there?
Yes, it is.
Have there been any changes made to this document or to any of the signatures pictured?
No.
Is this a true and correct copy of the signature comparison chart that you made in your analysis of Lou Donaldson's disappearance as an investigator?
Yes, it is.
Your Honor, at this time, we're offering Defense Exhibit B, which has been identified as Mr. Renard's signature comparison chart, and we constructively tender to opposing counsel.
Is there any objection to admitting this exhibit?
No, Your Honor.
All right, it shall be admitted.
May we also publish Exhibit B to the jury?
You may.
Mr. Renard, could you identify each one of the signatures in this chart here?
Yes. So the first signature is Lou Donaldson's signature on the Summit Life Insurance Company paperwork that he signed in 2005. The second signature is the one from Lou Donaldson's Statesville driver's license. And then the third signature is the signature from his last will and testament that was probated by Karen Baja.
Now, looking at these three signatures here, do they all look exactly the same?
No, they don't.
Would it be unusual if someone's signature did always look exactly the same?
Yes. In fact, one of the easiest ways to tell that something is forged is if the signatures are exactly identical. That says that the signature was copied precisely from another document rather than signed. No one's signature is the same every single time they sign it. So when we do see two completely identical signatures, that's a big red flag.
So based on your analysis of these signatures, would you mind pointing out a couple of the similarities that you noticed between these two signatures and the signature on Lou Donaldson's will?
Yeah, so it's worth noting in all three signatures, the top loop in the L in Lou is significantly smaller than the bottom loop. All of them have a tail coming off of the end of the U in Lou and a similar tail off of the N in Donaldson. And also the shape of the Ds is the same in all three. The shape of the first D in Donaldson is the same in all three of them.
Now, were you able to make a conclusion as to whether or not the signature on the will was genuine just from this close analysis?
So my initial analysis was not able to definitively determine that the signature on the will was genuine, although I did not have evidence that it was not genuine. Instead, I had to move on to other parts of the investigation and take a look at the totality of the circumstances.
Now, based on your 23 years of experience, is it unusual that you weren't able to determine whether or not the signature is genuine just based on this comparison at first?
No, as I said earlier, it's just something that happens in some of these cases is things will be inconclusive and that it's important to move on to other aspects to determine the overall authenticity of the document.
So when you got to the point that you started looking at the totality of the circumstances, is that when you were able to make your conclusion?
Yes, looking at the rest of the totality of the circumstances, I was able to come to a conclusion that the will was genuine.
What sort of circumstances did you look at?
Well, notably, I spoke to the witnesses who had witnessed Lou Donaldson signing the will.
Did you also look at the language of the will itself?
Yes, I did.
I want to take a look at that. I'm showing you on the screen what has been previously marked as Plaintiff's Exhibit 1, Plaintiff's Exhibit 3, the last will and testament of Lou Donaldson. And while we're pulling that up, you mentioned that you looked at the language of the will. What is your opinion as to the language on Lou Donaldson's will?
So for the most part, it's fairly standard. There is one unusual phrase, the phrase, if I should die or disappear. That is something that I had not seen before in a will.
Would this inclusion of this phrase by itself lead you to believe that a will is forged?
No, absolutely not. Wills often have unusual language. Everybody writes their own will their own way.
Did including the language in this will lead you to believe that this will was forged?
It did not.
Let's take a look now at the bottom half of these documents. What are the two signatures on the bottom half there?
Yeah, so those signatures are from the two people who witnessed the signing by Lou Donaldson. The first is from Samantha Lane, and the second is from Karen Baja.
Now, as part of your investigation, did you confirm with each one of these witnesses that they did, in fact, see Lou Donaldson sign this will?
Yes, I was able to speak with both of them, and they both confirmed that Lou Donaldson signed this will.
Mr. Nard, that's all the questions I had for you about the will. I'd like to talk to you about your conclusions now. Did you ultimately come to a conclusion about whether or not Lou Donaldson's will as a whole was forged?
Yes, my conclusion is that Lou Donaldson's will was not forged.
And Mr. Nard, as part of your investigation that you did in determining whether or not the life insurance should be paid out to Ms. Basha, what were you trying to determine with that?
Well, I was trying to determine whether anything that she had done or anything that had happened would invalidate the payout of that life insurance policy. The insurance companies were always looking for a way not to pay out $5 million.
And when you were investigating these circumstances to determine whether or not the policy had to be paid out, did you find any evidence in your investigation that made you believe that Ms. Basha should not be paid out the policy?
No, I did not find evidence of that. And in fact, my ultimate recommendation was that the insurance policy be paid, which is what Summit Life Insurance subsequently did.
Pass the witness.
Is there a cross-examination of this witness?
Yes, Your Honor. May I proceed?
You may.
Mr. Renard, you cannot say that the signature on the last will and testament is the genuine signature of Lou Donaldson.
It is my ultimate conclusion that it is in fact genuine.
It is your ultimate conclusion that it is in fact genuine.
Certainly it appears to be genuine, yes.
Mr. Renard, you prepared a report that you sent to the CEO of Summit Life Insurance prior to your testimony here today. Isn't that correct?
I did.
In that report, you made sure that all your conclusions were honest.
Yes.
Now, I want to redirect opposing counsel to what they previously admitted as Defense Exhibit B. I could kindly ask for opposing counsel to republish that to the screen.
Certainly.
Thank you so much. Now, opposing counsel, if you could please zoom in to the bottom in the notes. Now, Mr. Renard, I'm reading you what you wrote in your report that you submitted for this life insurance policy. Your words say, "I cannot say that the signature on the will is either genuine or non-genuine." Am I reading that right?
You did read that correctly, but I want to point out that it was an initial determination based on the first step of an investigation. If you look at my final report, the final report that I submitted, it says that I could not determine that the signature on the will was non-genuine and that it appears to be genuine.
Your Honor, at this point, I am going to object to improper impeachment just to have it on the record. Opposing counsel first questioned Mr. Renard that he did not conclude that the signature was genuine. However, looking both at this document and page 4 of his deposition, there is no prior inconsistent statement with what Mr. Renard said in court here today.
It's a fair objection, but I'm gonna let her run with this, given that this is your expert witness and he's been allowed to testify on the things that he has. So it's a good objection. I'm gonna overrule it for now.
Now, the only thing that you can actually say that in today's case is that the signature is close enough.
That's not the only thing I can say. What I can say is that given the totality of the circumstances, I was able to determine that the will was genuine. And if the will is genuine, then the signature must also be genuine.
But someone could have forged Lou Donaldson's signature on this will.
You know, it's possible, but unlikely that someone tried to copy his signature. But again, my ultimate conclusion here, given the totality of the circumstances, is that the will is genuine.
I appreciate you explaining that. So that's a yes to my question. Someone could have forged Lou Donaldson's signature on the will, correct?
It is technically possible, but unlikely.
Okay, I'm gonna ask opposing counsel to take down Exhibit B. Thank you so much. In fact, you actually had evidence that the document may have been forged.
I'm not sure what you mean.
Well, you received a letter in your investigation that references Samantha Lane being coerced into signing the will, did you not?
At this point, we are going to object to the admission or discussion of the contents of the letter as hearsay and that they cannot be authenticated.
Your Honor, if I may respond?
Yes, please.
Pursuant to Rule 42A of this tournament, it has already been determined that all exhibits are authentic and original copies as they purport to be. So in response to the authenticity, with respect to the hearsay argument, Mr. Renard has already been tendered as an expert witness on direct examination, and we recognize that 703 does not provide a basis for admission. We're simply using the letter as a demonstrative so the jury can fully understand and evaluate how Mr. Renard came to his conclusion that the will was valid. Moreover, the substance of the letter must be disclosed because the probative value of the substance of the letter substantially outweighs its prejudicial effect. This is something that Mr. Renard used to come to his conclusion.
Would you like my response, Your Honor?
Very briefly.
Your Honor, what opposing counsel just stated is that they are in fact offering this letter for the truth of the matter asserted, that it is in fact a letter from Samantha herself. There is nothing in this record and nothing Mr. Renard can say to authenticate that this is in fact a letter from Samantha Lane. Thus, that does not meet the authentication requirements of 901B1 that Mr. Renard testify that this is a letter from Samantha Lane. And additionally, we re-raise our hearsay objection that even with 703, the contents of this are highly misleading and inflammatory to the jury and substantially more prejudicial than they are probative.
Your Honor, if I may briefly respond.
No, it's okay. I've reached my conclusion. I'm going to overrule the objection. I think it's a fair objection. However, this is an expert witness who's offered very, very significant opinions in this matter. And the course of his investigation, the things he looked at and how he weighed them, I think are critical for the plaintiff to be able to explore on cross-examination. So I'm going to overrule the objection and I will allow him to be cross-examined on the letter.
Your Honor, just to clarify, we do still object to the publication of the letter to the jury before it has been admitted. So we just wanted to clarify that while your ruling does apply to questions about it, was your ruling that it may not be published or admitted at this time as well?
I don't believe we have a motion to admit the letter at this time. Is that correct?
Yes, Your Honor, as I previously stated, we're not seeking to admit this into evidence. We're simply seeking to use it as a demonstrative so the jury can fully understand the substance and contents of the letter. And if it may quell any concerns of opposing counsel, I do want to reiterate that we are not admitting it to prove the truth of the matter asserted within the letter, but simply to hear that so that the jury can hear the contents and fully understand how Mr. Renard reached his conclusion that the will was valid.
We do object to its use as a demonstrative under the best evidence rule, Your Honor, which would require not only that this be shown, but that it be admitted, and it can't because it cannot be authenticated. So while we will agree with Your Honor's ruling at this time that it can be discussed, we do object to its use as a demonstrative, also as it's highly misleading to the jury.
I'm gonna split this one. So I'm not going to allow it to be published as demonstrative. You're welcome to ask questions about it, and then we'll just see how it develops. And if there's further objections, we can address them at that time. Okay.
May I proceed, Your Honor?
You may.
Now, I'm directing opposing counsel to what has been bait stamped as 8 and the witness's attention to what has been bait stamped as 8. Now, Mr. Renard, you recognize this letter that has been bait stamped as 8?
Yes, I do.
And you recognize this as a letter that was sent in to you during your investigation into Lou Donaldson's will?
I do.
And this letter is a fair and accurate copy as you last saw it?
Yes, it is.
Now, you were the person investigating the insurance claim in this case, right?
I was, yes.
And this letter was sent to you.
It was.
And not only was it sent to you, but it was addressed to you.
Yes, it is.
Now, the insurance claim that you were investigating was the will of Lou Donaldson,
Yes, that's right.
and this letter talked about the will of Lou Donaldson.
It did.
And before receiving this letter, you spoke to Samantha Lane about the will, correct?
That's correct. She told me that she had witnessed Lou Donaldson signing it. Yes.
Now, this letter talks about that prior conversation with Samantha Lane, does it not?
It does.
And it references that the person who was signing this letter felt it was important for you to know that they weren't being honest when they last spoke.
No, I want to clarify that a little bit, because what it says is that it purports to be from Samantha Lane, but I want to be clear here. I could find no evidence that she actually sent this letter, and therefore, in my ultimate determination is that this letter was a hoax, and I relied on the communication that I was actually able to have and was able to confirm was with Samantha Lane, which was the earlier conversation.
All right. Well, we'll get there in a moment. Now, you're the handwriting expert here, right?
Yes, I am.
And this letter contained a signature from Samantha Lane
It did.
that you could have compared to the one on the will, correct?
I could have, yes.
But you didn't do that analysis.
I did not.
Now, let's briefly talk about your, okay. May I have a moment to confer with my co-counsel, Your Honor?
You may.
Nothing further.
Is there any redirect?
Yes, Your Honor. Mr. Nard, how many times have you testified as an expert witness in forensic document examination and as an investigator?
I have testified 25 times, and 24 of those were on behalf of Summit Life Insurance.
Are you familiar with the qualifications of what it takes to give an expert opinion?
I am.
Do you always make sure that your conclusion and opinions as an expert are relied on sufficient facts and data?
Yes, absolutely. Especially in insurance, anything can end up going to court. So it's very important that I stick to the facts and data that are sufficient and that I use standard methods for that purpose.
Mr. Nard, in cross-examination, you were questioned about a lot of possibilities. As an expert witness, do you consider the possibility that someone could have forged a will sufficient fact or data?
No, that possibility is not sufficient to come to an ultimate conclusion. What is sufficient is the totality of the circumstances surrounding the will. And in this case, though, that totality of the circumstances suggested to me and was my ultimate conclusion that the will is authentic.
And Mr. Nard, you also discussed a letter on cross-examination. Do you consider a letter that you can't possibly identify the sender of as sufficient facts or data?
I do not.
We have no further questions for this witness, Your Honor. May he be excused?
He may be. Thank you for your testimony.
And Your Honor, at this
Are there
point,
any other? Oh, go ahead, please.
at this point, Your Honor, defense has no further witnesses to present, and we rest our case in chief.
Okay, so we will take a brief recess to allow people to prepare for closing argument. I have it at 58 after right now. Can we get a brief time? Can we get a time check? I think we'll do a time check while everybody starts their recess. Does 5 minutes seem fair for everybody?
Yes, Your Honor.
Your Honor.
Okay, so let's take 5 minutes. I'll give you a little extra. Try to be back by 4 after.
Yes, Your Honor. Thank you.
Okay, there we go. I was staring at my ugly mug just frozen on the screen, but we're back. We have 1 more minute, so we'll check in just a moment. All right, can I get a check-in from the plaintiff if we have everybody here?
Everyone's here, Your Honor.
What about for the defense?
Everyone here is from the defense as well, Your Honor.
And it looks like we did receive a time check. Did everybody see it there in the chat window?
Yes, Your Honor.
So plaintiff has 14 and a half minutes remaining. Defense has 21 minutes remaining. Thank you, timekeepers, for doing that. Is the plaintiff ready to proceed?
Yes, Your Honor. At this time, I would ask to reserve time for rebuttal as well.
Absolutely.
May I proceed?
You may.
$10 million. The defendant killed her husband for $10 million. That's the only reason we're here today. And that's the only reason why Cam Donaldson sits before you today without a father. All because the defendant let her greed get the best of her. They say money makes people do crazy things. Well, the fear of losing money and the selfish desire to keep it no matter what, well, that drove the defendant to create a plan to kill Mr. Donaldson, take his entire estate, and cover it all up. 2 days after Mr. Donaldson asked the court for a restraining order against the defendant, she forged his will. 2 weeks after Mr. Donaldson asked the defendant for a divorce, he mysteriously goes missing without a trace. And it took 2 months from the day that Mr. Donaldson filed that restraining order to the day he went missing for the defendant to think of and carry out her plan to make sure that the lavish lifestyle she had become accustomed to wouldn't be stripped away from her by a divorce. You see, the defendant didn't just want a cut. She wanted everything, all 10 million of it. And she was going to do everything in her power to get exactly what she wanted. And unfortunately, she did. Because when the defendant realized that Mr. Donaldson wanted her out of his life, she decided to take his instead. At the beginning of today's trial, my co-counsel Alice Vagan came before you and explained that we as the plaintiffs have the burden by a preponderance of the evidence to prove that the defendant should be held liable for wrongfully causing the death of Mr. Donaldson. Preponderance of the evidence, in other words, means more likely than not. So imagine you're looking at a scale that appears to be even. Then put one feather on one side of that scale and it slightly tips. That right there is preponderance. And now, at the end of this trial, after seeing all the evidence and hearing all the testimony, it has become clear that we have met our burden and that the defendant should be held responsible for wrongfully causing Mr. Lou Donaldson's death. Now, in a few moments, the judge is going to instruct you on the law, but before he does, I'd like to discuss it with you. See, we as the plaintiffs had to prove these 4 elements: that Lou Donaldson is dead, that the death of Lou Donaldson was caused by the defendant's intentional or reckless conduct, that the plaintiff Cam Donaldson suffered injuries, damages, or losses as a result of the death of Lou Donaldson, and that the defendant's conduct, either intentional or reckless, was the cause of the plaintiff's injuries and damages. So I want to go through all of these elements so we can see just how every one of them have been met in today's case. Starting with number 1, that Lou Donaldson is dead. Now, we heard today that Mr. Donaldson has been declared legally dead. Specifically, he was declared legally dead by none other than the defendant. And just to be clear, just because Mr. Donaldson has been declared legally dead doesn't automatically mean we've met this first element. But consider that fact along with the other evidence we have in this case. Take the bank records that Mr. Pry talked about today. He told us that from those records, he saw that the last time Mr. Donaldson ever touched any of his finances was on August 17th, 2012.
Your Honor, we are going to object at this time, as the mention of the financial records is not evidence that was ever mentioned during this trial and is not evidence that was ever admitted. And under Rule 403, we ask this court to strike this, as speaking about evidence not admitted would be extremely misleading to the jury.
Your Honor, if I may
Is there a
respond.
response to that? Yes, please do.
Your Honor, Mr. Pride did testify that he looked at the bank records and saw from those records that the last time he touched the finances was on August 17th, 2012. I questioned him about it, and that's what he answered.
I'll be candid, I don't remember exactly his testimony. It's a good objection. In the real world, obviously, we would sort this out. But for now, I'm going to allow it based on that proffer of what the testimony actually was. So you may continue.
Yes, Your Honor. We know from those records that Mr. Pride told us the last time Mr. Donaldson touched any of his finances was on August 17th, 2012. The last time anyone ever saw Mr. Donaldson alive was August 17th, 2012. Members of the jury, we don't need proof of a dead body to show that Mr. Donaldson is dead because there are simply no signs of him being alive anywhere. And as a result, we have proven the first element in today's case. Now, I want to look at elements 2 and 4 together because if the defendant intentionally caused Mr. Donaldson's death, she intentionally acted to cause damages to Cam. At this point in the trial, we know that the only person in this entire case with a motive to kill Mr. Donaldson was the defendant. And the only person with the resources to get it done was the defendant. Simply put, all the facts point to the defendant being responsible for the death of Mr. Lou Donaldson. Now, in a few moments, opposing counsel will come before you and try to make you believe that it would be absolutely ridiculous to think that Ms. Baja wanted to kill Mr. Donaldson, let alone be able to carry out such a plan, all while leaving no DNA or fingerprint evidence behind. But members of the jury, when you look at all the pieces of the puzzle here and use your common sense, it becomes clear that the defendant, consumed by greed and in fear of losing her newly acquired wealth to a divorce, killed Mr. Donaldson and made it seem like she had absolutely nothing to do with it. So let's talk about that evidence and see just how all those pieces of the puzzle fit together. We heard about how Mr. Donaldson and the defendant met. That they were 20 years apart, that when they met, Mr. Donaldson was very wealthy, and the defendant was not. You see, she came from a poor upbringing, but when she met Mr. Donaldson, her life changed. She hit the jackpot, and she knew it too. Now we know that she was only in it for the money from the very beginning. That's why we heard from Cam and the defendant herself that their marriage had problems. That's why Mr. Donaldson wanted a divorce, but the defendant didn't. That's why Mr. Donaldson went to court and tried to get a restraining order against the defendant. Members of the jury, with the defendant's intent in mind, let's talk about how she acted on that intent, because the question still remains. How did she do it? Well, we know now that Miss Baja killed Mr. Donaldson by putting him in the meat grinder at Wild Wildlife and feeding him to the cats. And as crazy as it sounds, it's the only reasonable conclusion we can come to. Let's look at the facts. The defendant told you that she was at Wild Wildlife in the early morning hours of August 18th, 2012. The last time anyone ever saw Mr. Donaldson alive was when Cam said goodbye to his father on the night of August 17th, 2012. The fact that Mr. Donaldson disappeared that very same weekend is absolutely no coincidence. We also heard today from the defendant that there's a meat grinder at Wild Wildlife, which she knows how to use, and which is used to grind up large pieces of meat into little pieces of meat for the cats to eat. Now, even if this meat grinder does take 2 people to work like the defendant told us, we know that she was with her brother that night, the deputy sheriff. Her brother, who works for the same police department that would have arrested her had she been charged with anything. Then we heard that about a week after August 18th, she went to go pick up Mr. Donaldson's van with her brother, the deputy sheriff. We heard that inside that van was Mr. Donaldson's keys, and what Cam told us was the glasses that Mr. Donaldson never flew without. Cam also told us that when he arrived to Wild Wildlife on the weekend of Mr. Donaldson's disappearance, he arrived at the scene of a break-in with the lock cut and the gate broken into. He told us that when he got there, he saw the defendant with another individual. That individual was carrying a lock cutter, and the defendant was carrying a lockbox that contained Mr. Donaldson's real last will and testament. Speaking of that will, we heard from Mr. Taylor Pride today, an expert in the field of forensic document examination, who walked us through the detailed process he goes through in forgery investigations. He told us that when he applied that process to the facts of this case, he concluded that the will was forged. Now, he also told us that during his investigation, he noticed that the will leaves everything to the defendant should Mr. Donaldson die or disappear. He told us of the hundreds of wills he's looked at over his career. He has never seen that language before. And you know why? It's because people don't plan on disappearing, members of the jury. We know Mr. Donaldson didn't write that in his will because it was forged by the defendant as part of her plan to kill him and take his entire estate. When Cam said goodbye to his father on August 17, 2012, he didn't know he was saying goodbye forever. Sadly, now we know that it was. More importantly, we know that it was because of the defendant. The defendant who told you herself that while Mr. Donaldson would go on trips, he would always come back. But this time he didn't. And it wasn't because he just disappeared. It's because the defendant killed him. Because we know that the defendant intentionally forged Mr. Donaldson's will and intentionally acted to kill him, we know that she intentionally acted to cause damages to Cam Donaldson. And as a result, we have proven elements 2 and 4 in this case. Now for the third element, the damages caused to Cam. Members of the jury, this element is undisputed. Cam suffered one of the biggest losses imaginable. Life of a loved one. He worked with his father almost every single day and of course, loved him very much. Now because the defendant will never be able to see his father again. And as a result, we have proven each and every element in the claim brought forward here today. Now, the loss that Cam suffered is a loss that he will never be able to fully recover from. More importantly, it's a loss he never should have had to suffer. But you see, this is what the defendant wanted. Cam lost his father so the defendant could win $10 million. That's just not right. But you have a chance to correct that. When you go back to deliberate today, you're going to get a verdict form that's going to ask you to assign a dollar amount to what you think is equal to the losses Cam has suffered in this case. And just to be clear, no amount of money in the world will ever make Cam whole again for his father, but this is the closest thing the law offers to making that happen. That is why I suggest that you return a verdict of $25 million for the losses that Cam has suffered in this case. Because up until now, the only person who has suffered the consequences of the defendant's actions is me, Cam. You have the power to make that right. Find the defendant liable.
Thank you, counsel. Would the defense like to provide a closing argument?
Yes, Your Honor. May it please the court. A free-spirited, eccentric man who wouldn't settle for the usual white picket fence and standard 8-to-5 job. No, instead, he raised and rescued tigers. And when he wasn't doing that, he was getting in his planes and jetting off to whatever idyllic island he wanted to see next. But that was just Lou Donaldson, a secret multimillionaire. He had many planes. You heard today that no one knew how many, not even his daughter, his son. And he didn't even file flight logs, so not even his wife knew when or if he'd be home. And even Lou Donaldson knew that he could just disappear whenever he wanted. That's why he included that die or disappear language in his will. And then on August 17th, 2012, Lou Donaldson did what Lou Donaldson has always done. He got in his plane, he went off, and he didn't tell a soul. And despite two impartial and neutral parties looking into the cases, the sheriff's department and the insurance company, to try and find out what happened, there was no evidence of what actually happened to Lou Donaldson. But one thing is clear. There was no evidence that Karen Basha was involved, and a third time won't change the truth. Members of the jury, the plaintiff came here today to try to tell you that Miss Basha is here for $10 million. But the only person that's here to get money, $25 million, and her $25 million reason why is Cam Donaldson. And there's a reason here why you've heard so much about money, and yet you've been presented with no evidence that Miss Basha had anything to do with Lou Donaldson's disappearance. There's an obvious answer why it's been 8 years since Lou Donaldson disappeared and Miss Basha hasn't been convicted or arrested or even spent a night in jail. There's a reason it's been 8 years and plaintiff hasn't been able to come up with any evidence that Miss Basha caused the death or disappearance of her husband. She didn't do it. Now, members of the jury, plaintiff wants you to believe in possibilities and rabbit trails, but I want to show you on your screen what you're going to be presented with at the end of this trial. Instruction number 8. I want you to think back to the cross-examination of Chris Renard, where plaintiff's counsel tried to convince Chris Renard to believe in possibilities, but members of the jury, Chris Renard can't do that and neither can you. If we look at instruction number 8, you're going to be instructed by the judge that you can't base this case off of possibilities or speculation. And at the end of this trial, that same judge is going to come before you and ask you whether or not you think that Karen Basha intentionally killed Lou Donaldson. You're going to be presented with a verdict form at the end of this trial as well, and I'm showing you on your screen what's been marked as verdict form B. Members of the jury, as the party that brought this case, plaintiffs do have the burden of proof here. However, unlike what plaintiff told you, this isn't just a weighing of the scales, no. Plaintiff's burden starts at 0%, and they have to work their way up to meet the preponderance of the evidence standard. It is not as simple as a tipping of the scales. Members of the jury, it is the greater weight of the evidence. And from what you've seen today, from the greater weight of the evidence, because you've been presented with no evidence that Ms. Basha was involved at all, and because you have two impartial findings to the opposite, the only verdict form here today that is going to accurately reflect the greater weight of the evidence is verdict form B. Now, you just heard plaintiffs talk to you about the elements of a wrongful death claim here in Statesville. And they showed you 4 elements, and I want to show you 2 of those on your screen again from instruction 13. There are 4 parts to this, but what this really comes down to are 2 things. Because no one here contests the fact that legally, Lou Donaldson wasn't seen for 5 years. So legally, Lou Donaldson has been determined dead. However, we don't know if he's actually dead, or neither do they, because you haven't been presented with any evidence of that either way. Additionally, we don't contest that Cam Donaldson has suffered loss due to the death or disappearance of her father. However, plaintiff has failed to prove to you the other 2 elements that they are required to do for their cause of action. First, that Ms. Basha intentionally killed Lou Donaldson. And second, that Ms. Basha is responsible for Cam Donaldson's injuries. Members of the jury, you heard it best from Cam Donaldson herself. She has no evidence, 0 firsthand personal knowledge that Ms. Basha had anything to do with Lou Donaldson's disappearance, because that evidence doesn't exist. Instead, what you've learned today is that it's possible that Lou Donaldson is dead. It's also equally possible that he's sipping a Mai Tai off on a beach in Costa Rica. It's possible that Lou Donaldson got in his plane and went on one of his adventures. And from what you've heard today from Cam Donaldson and Karen Basha as well, that wouldn't be out of the character for Lou Donaldson. And that's exactly what you heard from both experts here today, that they don't know where Lou Donaldson is. Members of the jury, no one does. And you heard from Chris Renard today, who is an expert investigator for Summit Life Insurance, who Chris Renard, unlike the plaintiff's expert, wasn't even paid by Ms. Basha to be here. Chris Renard, who gets nothing out of the fact that saying that Ms. Basha should or should not get the life insurance payout. However, Summit Life Insurance job was to find any possible reason not to pay out that policy to Ms. Basha. They couldn't find a thing, not a single reason not to pay it out. Instead, the plaintiff wants you to believe that Ms. Basha killed her husband on August 17th, but members of the jury, you heard today that Ms. Basha was busy. She was busy taking care of newborn cubs and going out to buy milk for them. And while the plaintiff wants you to believe in these possibilities, all they've presented to you today is evidence that a married couple argued, and evidence that because there was a meat grinder on the property of a sanctuary, that it must have been used to disgustingly grind up a human. But I want you to remember something today. Coincidences are not causation. All the plaintiff has tried to show you today is that Karen Basha forged a will. But not only have you seen that will today, you heard from Chris Renard, that will is genuine, looking at the totality of the circumstances and the signatures on there. The only thing that plaintiff's expert Taylor Pride proved to you about the signature is that Lou Donaldson got older. Members of the jury, plaintiff's counsel came up here to you and they spoke to you a lot about a single reason why we're here, about how Ms. Basha must be here to get the money. But there's a reason why plaintiff has spent so much time today trying to convince you of a forged will. And you just heard plaintiff's counsel get up here and ask you not for $10 million, but for $25 million. I want you to think back to the cross-examination of Mr. Donaldson. Cam Donaldson told you that it's important to honor the wishes of the dead. Cam Donaldson also told you about this original lockbox will that would have divided up Lou Donaldson's estate in 4 ways, giving her $1.25 million. But Cam Donaldson isn't here to ask you to reissue what Lou Donaldson would have wanted in that original will. Cam Donaldson is here to get the entire $5 million estate, even though that's not what was left to him in that original will. Cam Donaldson is here to get the entire $5 million life insurance policy, but members of the jury, what you heard today is that that policy was signed back in 2005. 7 years between when Lou Donaldson signed it and when he disappeared. 7 years to change the beneficiary to who currently wants the money, Cam Donaldson, and Lou Donaldson didn't do that. And he didn't do it in that original lockbox will either. Cam Donaldson came here today to get the deed to Wild Wildlife Sanctuary. Members of the jury, you heard from Cam Donaldson himself. He worked there with his dad for 11 years, and during that entire time, he never got ownership to the sanctuary, and he didn't get it in that original will either. The truth is that Tiger Sanctuary wasn't the dream of Cam Donaldson. That sanctuary was co-founded by Ms. Basha and Lou Donaldson. Cam Donaldson wants you to give her all of this, yet she's presented you with no evidence that that's what Lou Donaldson would have wanted. And members of the jury, if there is any doubt left in your mind at this point, I want you to remember how Cam Donaldson talked about this close relationship that she had with her father, but she didn't hire an investigator the day his dad disappeared, or a week after, or a year after. Cam Donaldson waited to hire an investigator until 5 years after Lou Donaldson's disappearance, because that's when he found out that he was going to lose his inheritance. I'm showing you on the screen now the last will and testament of Lou Donaldson. Plaintiffs want you to believe that Karen Basha forged this will and killed her husband for money because they want you to believe this story, that because Karen Basha was poor growing up, that she married a multimillionaire not for love, but to kill him later on and take all of his money. But members of the jury, Karen Basha was always getting money from Lou Donaldson. Karen Basha was always getting a fourth of that original will that Cam Donaldson wants you to believe existed. That's 1.25 million. Karen Basha was always the beneficiary of the life insurance policy. Another $5 million. That's a total of 6.25 million. Members of the jury, Karen Basha didn't kill her husband for money because she was always going to get money in the first place. But you know who wasn't? The one person here that's asking you to give them $25 million. Cam Donaldson. You heard from Ms. Basha herself that her relationship with Lou Donaldson started with Lou Donaldson taking care of her. Members of the jury, that is exactly how their relationship ended. With a will from Lou Donaldson leaving his estate to Karen Basha, his wife. Members of the jury, your job here today is not to guess or to speculate or to base your decision here on possibilities. Your job here today is to look at the evidence and see what happened, because that's what justice demands of you. And you can't determine that Karen Basha is responsible today because you've got no evidence of that. And the plaintiff today wants you to believe in these possibilities that they've presented to you. And these chances that because something might have happened, it means it must have. But justice is not based on possibilities and speculation. And Karen Basha, don't forget, has already been investigated twice by Summit Life Insurance and by the Sheriff's Department, and now she's been dragged here a third time to relive it. When are we going to say enough is enough? Members of the jury, there's no $10 million reason why Karen Basha is here, because she was always going to get the money regardless. But even so, the only reason we're here is because Cam Donaldson wants her $10 million reason, now her $25 million reason, to sink her claws into Lou Donaldson's fortune. But this evidence has already been looked at once. It's already been looked at twice. And there was no evidence that Karen Basha had anything to do with Lou Donaldson's death or disappearance. And a third time, it's not going to change the truth. We look forward to your return of verdict form B.
Thank you, counsel. Mr. Betzelos, do you have a rebuttal argument?
Yes, Your Honor, I do.
You may proceed.
This isn't Cam's last shot to get paid. This is Cam's last shot to get justice for his father. Cam told us today that his dad told him, if anything ever happens to me, be sure to look into the defendant because she will be responsible for my death. Cam is here because he's listening to what his dad told him, even after he lost him forever. Now, just like I told you, opposing counsel came up here and harped on the fact that because there's little evidence regarding DNA or fingerprints in this case, we can't prove that Karen Basha was responsible for Mr. Donaldson's death. But members of the jury, when you're deliberating on this in this case, I want you to pay close attention to what is called the circumstantial evidence. And you're going to get a jury instruction that's going to explain to you exactly what circumstantial evidence is, but basically it's the reasonable inferences that you can draw from the evidence that we do have in this case. And that jury instruction is also going to tell you that the law makes no distinction between the effect of direct and circumstantial evidence. You see, we as the plaintiffs don't get to pick and choose what evidence we have. Think about it, that's up to the defendant. We work with what we got. And what we have is more than enough to show that the defendant is responsible for Mr. Donaldson's death. Now, I want to talk about the defendant's alibi in this case. On August 18th, 2012, she could remember going to the store. She could remember what she bought at the store. She could remember exactly what she was doing when she went back, all of that. But when I asked her simple questions about this random person that pulled her over on the side of the road, she couldn't answer one single question. Why is that? It's because she's hiding something. And we now know that what she was hiding is the fact that that was the day that she killed Mr. Donaldson. And just to be clear, members of the jury, Cam is not asking for a specific amount of money in this case himself. That's not why he's here. I did ask you to return a verdict, but that's just a suggestion. Regardless, that decision is up to you. But opposing counsel wants to put a price on a human life. That's impossible. What isn't impossible is proving that Karen Baja killed the defendant, because that's exactly what happened here in this case, members of the jury. Remember that the only person in this case that had a problem with Mr. Donaldson in any way, shape, or form was the defendant. The only person in this case with the motive to kill Mr. Donaldson was the defendant. And the only person with a brother who's a deputy sheriff and all the resources to get it done the exact way I explained to you that she killed him was the defendant. And now she needs to be held responsible for her actions. Find the defendant liable.
Thank you, counsel. That concludes our case, and it will be submitted to the jury. I want to thank all of you so much for your great presentation and argument, and it was very fun to watch, so I really appreciate it. Before I let you go, it's my understanding we are not to provide feedback. I want to ensure that the scoring jurors have all the information they need in order to submit the ballots. So I'm going to turn to the scoring jurors. Is there any information you need to clarify before we let these fine individuals go?
This is Robin Andrews. Nothing needed from me. Thank you.
This is Darius Wade. Nothing needed from me as well.
All right. Well, thank you again, and best luck to all of you as this goes forward. Again, it was very enjoyable. So keep at it.
Thank you so much. Good job, guys.
You too. Thank you.